Welcome to our third meeting of the Rural Advisory Committee for the Water Right Transactions Rulemaking. We have a few more meetings to do after this one, but I'm really excited for seeing friendly faces on the screen and in the room. And then quick reminder of some logistics for folks here in person. We have some refreshments over to the side there. Feel free to help yourselves. And then for folks who actually, I think most people have been here before, but restrooms are out there and to the left, as is the stairwell if you needed to leave the building. And to the right is the elevator and then a water station. So I'm going to hand it over to Laura for the next part of the agenda.
Okay, thank you, everybody. So this is what we're going to go through today. We've got a lot going on this week, today and tomorrow. Today, we're hoping to get through Division 310, 18, and 315. Before we get into the draft rules, I just have some housekeeping items to talk us through. First, you all should have received the meeting summary from our first RAC meeting. And we've asked you to take a look at that summary and see if it reflects to your best recollection what transpired during the meeting. I will say it's meant to just be a summary. We have also posted the recordings of the actual meeting. So if you want to go and review the transcript, that's another way to get the meeting content. We do have the summary for the second RAC meeting, draft summary for your review ready as well, but we're going to send that out on Thursday to give you a little bit of a break so you can focus on, the next today and tomorrow's meetings. So we do have the RAC 2 summary ready to go as well. This is just a reminder about the rulemaking timeline. I think as we last time we spoke, we did clarify that we would be going to the commission in March for adoption. So we're sort of backing into that date. Planning to notice January 2nd, roughly 30-day public comment period, holding public hearings in late January, last day of public comment. Early February, it's going to be February and a little bit of March, reviewing the input and incorporating it as necessary into our final proposal that we'll take to the commission. And then some updates on our meeting schedule. Thank you all for completing the polls and providing availability for November. Should have gotten this information in an email I sent out last week, but the 2 dates in November we landed on are November 12th and November 21st, both in the morning, same schedule, 8:30 to noon. And then a little bit of an update on Division 2nd. And I might pitch this over to Raquel to fill folks in on what we're doing with the Division 2, the follow-up meeting. So we did ask RAC members who might be interested in a follow-up. We heard from a handful of folks. I think we've got 2 dates that are still in play. I'm waiting to hear back from actually Jeff's person.
Marika?
Yes, yeah, from her. I left her a voicemail yesterday. And we'll have a revised version of Division 2 that'll incorporate some of the OAH input that we've received, and we will share that with the entire RAC. And
Laura, what are the 2 dates? Because Jeff's gonna
I'll ping her right
ping
now.
her right now, because we need to get that figured out now. So
trying to remember, Kimberly, October 20th,
there's 20th and 31st, right?
31st. Yeah, those were the 2.
Those are the 2 dates that we were looking at.
I don't know that we can make.
You guys said 31st was best and 20th was you could manage, and then the other date,
Okay.
which is the 12th, was just completely yesterday. It was completely out. So
I think it was.
Yeah.
and we'll do the 31st if she's available on the 31st. She's based on preference. So okay. Are there any questions about the updated schedule or anything we've talked about? Okay, I guess we can launch into the rule discussion.
Okay, great. Thanks so much, Laura. And then there may be some that we'll want to see on the screen at some point, so you'd be able to share those if we get to that point. Laura, you'd be able to share those.
Yes, I'm working on pulling it
Awesome,
up.
thank
Yeah.
you. All right, and another clarification, we are doing Division 18 last, so we'll do 310, 315, and Division 18. Division 310 is water right application processing, and so April, I will try and do the reasonable thing here, which is to say the division names along with the number. We've just been living in the numbers for so long, it's almost second nature to us. So we'll be covering water right application processing rules at 310 before moving into extension rules next at 315. Starting off, the first one, very simple change. We're updating rule reference to the transfer division rules. Used to be 15, now it's 380. That's pretty straightforward. I'm just gonna walk through sets of rules and then I'll pause and see if anybody has any questions. The next one, scrolling down, used to say, so 0010 application processing rules, control general administrative procedures act provisions. Thank you. Oh, great.
Glad that you know who you are.
I do, yeah. So that language, currently in rules says that water laws in ORS 537, supersede the Administrative Procedures Act if there's conflict. We're repealing that rule or proposing to repeal that rule because Division 2 and House Bill 3544 are now the governing authorities. Moving on to the next one at 0020, requirement to notify owner of land crossed by proposed ditch, canal, or other work. So this is a due process improvement. If someone is requesting to, if they're applying for new water right on somebody else's land, so someone who isn't the applicant, then they need to be notified for due process requirements. So it's directing us to notify those folks. Moving on to application requirements, and then after I get through this one, I'll pause and see if folks have any questions. So 0040, application requirements. We're requesting email addresses if folks have those available to allow for our electronic notification. We're also requiring the name and mailing address of any landowner who has land within the place of use if they're not the applicant, so that we can provide that notification I just discussed. What?
No, so let's pause for a second.
Yeah.
Because if we get too far down, let's check in and see if folks have comments on, the first set there.
Yeah.
And if you can note, just land use is gonna show up.
Yes, okay, I'll note that. Do you want, I was gonna get through this one first and then pause but Raquel wanted to see, I've gone a little fast. So does anyone have any questions so far? Oh, we've got Austin on the screen.
Sorry, so awesome.
Hey, good morning. I just have a couple comments to make. I like the way that it's laid out, but I believe it should be like within the proposed place of use when mentioning the place of use in these subsections.
Thank you.
And that's it.
Kimberly,
Just on, in removing the section on the APA, I just want to remind the department that water watch needs some comments on Division 2 about continuing to tie to 183 and OAR 137. And so I've noticed throughout the rules, you're only referring to Division 2, but if Division 2 does tie to those other two, it's fine, but if not, then we'll probably provide comment comments, does that make sense?
Say the two,
It's
references that you're
ORS
looking for.
183 and then OAR 137.
Yes, it will do that when it's appropriate in Division 2.
Okay.
And if it's, but we'll keep an eye on that.
Okay, and so I won't, it's throughout all of these, so
Okay.
I'll just.
and
say
you'll
it
submit a
as one.
comment on
Yeah.
that. Yeah, I appreciate that. Thank you, Kimberly. No other questions? We'll keep going. So again, we're in application requirements. This next one adds some clarity about what we need to do our evaluation of if the proposed use is compatible with the acknowledged comprehensive plan of the local government. So, you know, that's some of the rule language we already had there, but adding clarity about our land use information form. As folks who've gone through the process before know, that's filled out by the local government. And it should provide information that allows us to see that the proposed use is compatible with the acknowledged comprehensive plan. So that adds clarity there.
So Leah's,
Yes, hi, Leah, go ahead.
Hi, Leah Kogan with GSI. This does, so I think we mentioned last time that, you know, this means that you have to have the entire land use form filled out. You can't just turn in the stub at the bottom. That's fine. And then understanding that, you know, if you don't hear back in 30 days, you can't just assume that it's compatible with the land use, and that's understood. However, this kind of, I mean, you've eliminated the reference to the land use planning procedures guide. Is that going away? And it also eliminates any reference to Division 5. And so I think this could be a little bit clearer to show, you know, if it's still going to be consistent with Division 5. So on the land use form, you know, we'll turn in the whole thing, but can you still be able to check the box for being pursued as far as the land use compatibility, or does it have to already be that all land use approvals have been obtained and all the appeals periods have been exhausted? Because that would be a real problem for many applicants if you're going to change it to that.
Yeah, thank you for your comments and your question there. So you are, and you probably already have seen, Leah, if you've gotten a chance to look through 310, so this is kind of teeing some things up for us. We have another part of the rules that I'll get to, but I think it's worth mentioning now, where Division 310 has a rule that I'll get to, where it says if we haven't heard back from the local government within 30 days of when we release our IR, that we just assume it's compatible with the acknowledged comprehensive plan, and that is not consistent with our responsibilities under ORS 197-180. So that is state agency rules, plans, or programs affecting land use are not compatible with an acknowledged comprehensive plan if the state agency takes or approves an action that is not allowed under the acknowledged comprehensive plan. So we need to know that the action that we are taking or approving is allowed under the acknowledged comprehensive plan. If we don't have sufficient information at the time of application intake to make that decision, we don't have a complete application. So what we've seen is that that stalls processing. That can be, in some cases, years of back and forth with the applicants trying to get that information. So this is in part a streamlining effort, but it is also recognizing we need this information to comply with ORS 197-180. So it isn't the part of the rules that I'll get to later that says we don't know, therefore it's okay. That's not compliant with 197-180. So here, the land use planning procedures guide, Division 5, those are still in place, but this provides that clarity for folks. So, you know, we're using that land use information form, which is designed to get at the information we need to comply with 197-180. If somebody is, let's say the county comes back and says that it is compatible with the acknowledged comprehensive plan, but someone is in an administrative appeal process. We do have, when we talk about the admin hold process later in these rules, there is the ability to request an administrative hold on processing to allow for them to get to that appeals period. But that would be a situation where the county would have said, this meets the acknowledged comprehensive plan. It's just an administrative appeal period.
And so the part in Division 5, and I don't have it open right now, I'm sorry, but where it says that if the land use approvals are pending, you can still issue a permit that has a condition saying you know, here's your permit, but you can't actually use the water until you provide that land use approval information to OWRD. So that's in Division 5, and I've seen that on several permits for municipalities, since it can take years to get through the design and construction process and getting all of their permitting and land use approvals. So I think that would be extremely difficult for a lot of municipalities to comply with. Especially if they're doing, you know, a large storage project or some kind of large, you know, infrastructure, water treatment plant, you know, millions of dollars are being spent. If they don't have their land use approvals at the time of the application, which is usually, you know, it can be something that happens later in the process. So this is kind of out of order of how it would work as far as, if you're a municipality trying to get financing to, construct a large infrastructure project. And you have to have proof that, there is actually going to be a water right in order to get funding. So this is kind of backwards.
So, understand your point. But so that part of Division 5, I'm familiar with what you're referring to, Leah. And so it says we can do that if it's compatible with all statutes and rules that the department must follow. And one of those statutes is ORS 197-180. So Division 5 is basically saying we can only do that if we know that the action that we are taking or approving is consistent with the acknowledged comprehensive plan because of that reference to statutes that govern our actions. I'd be interested in any comments that you want to submit on this, but the bottom line here is we do need to comply with our statutory obligations.
I think we will be putting together some comments. Thank you.
Great. Thank you. Michael.
Yeah, I just want to add some additional comments to, what Leah's provided so far. I again, to underscore the point, I mean, this is very problematic for municipalities. How we pursue bonding authority before we can get debt approved, that, for WIFIA loans, Safe Drinking Water Act, like any of that, we have to have that water right permit. And usually the, land use is part of the overall project permitting, which kind of my understanding occurs around like 30 to 60% of design. And we would really need to have that ability to have that approved. So this, certainly for the sake of time, want to make this very clear that this is very problematic and we could be, provide more detail in comment as well.
Thank you, Michael. I have a question for you. So the words we have on the page there say information sufficient to assess compatibility with the acknowledged comprehensive plan. It doesn't necessarily usually means that somebody's received that land use approval, but that's not exactly what the language says there. And so wouldn't the local government, the county, be able to tell us if the action is compatible with the acknowledged comprehensive plan, even if that land use approval hasn't been issued yet?
So what, yeah, help me understand, what's the question then?
Yeah, so I think what I'm hearing you saying, you can correct me if I'm wrong, is that there's concerns about the amount of time it may take to get the land use approval. Is that right?
Yeah. Yep.
Okay.
I mean,
And
that,
so,
yeah, that's
great.
yeah. It
Okay.
kind of, it's like, it seems to, I mean, kind of, talking with SMEs and, our folks are like, the problem there is that, so is it implying that that sort of has to be exhausted before? Because the way that projects are financed, I mean, this is, these types of projects and even the ones that Leah had mentioned are, this could present a huge problem for us, like how we go out and get bonding authority and debt approved.
Right, and so Michael, the words that we have on the screen here, I wanted to ask for your thoughts on that specifically. So it doesn't say a land use approval in hand. It says information from the local government indicating that the action that we'd be taking is compatible with the acknowledged comprehensive plan. So in the scenario that you're talking about, do you think that the local government would, in most cases be able to say, this is compatible with the acknowledged comprehensive plan, even if the local government hasn't issued the approval yet?
Yeah, I mean, we have 241 members, so I mean, there's going to be different answers to that question, from across our membership. So, I think maybe, certainly we'll provide more comment in detail and happy to, answer that portion specifically. I don't want to get too over my skis on that in that respect.
I appreciate your input. Thank you. Hey, Jeff Stone, go ahead.
Good morning. So I get the financing part that our municipality friends are talking about, but what what's the department's feeling when you're considering this type of language, if there's a conflict on land use, so say something's before the Land Use Board of Appeals, say like a water treatment plant out in Gresham that sucks.
Sounds
And
rather specific.
it's very specific. If there is conflict on the land use side, I mean, so what's the order in which the department would, enact this part of the rule?
So would that be a circumstance where the county's indicated, or maybe the city's indicated that the action they believe is consistent with the acknowledged comprehensive plan, but there's been an administrative appeal? Is that the kind of scenario?
Well, yeah, I mean, yes, I would also venture without getting over, I mean, I'm not a lawyer, but, this body, the legislative body passed an urban rural reserve.
Okay.
And they're putting a urban use in a rural area, and that's the basis of the land use appeal.
Okay,
But if there's conflict within, let's say, laws that have been passed, I'm just curious about how the department can adjudicate something when there may still be active litigation.
so if we're in a circumstance where the county's indicated that they believe it's consistent with their acknowledged comprehensive plan, but somebody has appealed, say, to LUBA, then we have something that I'll get to later in our rules that allows an applicant to say, we need more time, we're requesting an admin hold on your processing of the application to allow that administrative appeal period to close and for them to get that final action.
Okay, I'm just curious, because when you delve into the land use side, it tends to get a little trickier.
It absolutely does, yes.
Okay,
Yes.
thank you.
Yeah.
We have 3 hands in the chat.
Oh,
Yeah.
great. All right, you know who's first?
Chris
In
Hall.
order, well, it's in order, Leah, Greg,
Okay.
and Chris.
Leah.
Yes, so I'm thinking of situations where it's not just that, the county, for example, has said that this land use is approved outright and, this is all compatible and that, but there's some appeal. But in a case where there needs to be a zoning change and that is in progress, and, it has not quite happened yet. So I want to be clear, like to understand what you're saying. So there's no longer going to be an option for this is being pursued, but it's not yet approved, like it's not actually compatible outright, but it will be. Is that no longer okay?
I would want to evaluate a specific scenario like that, but really looking for the local government to tell us the action would be compatible with the acknowledged comprehensive plan. Even if there are additional steps to take, having that information from them is what we're looking for. So, I encourage, of course, as part of the RAC, that we receive comments on this from folks who are interested. But to the extent possible, I would also ask that folks look at our obligations under ORS 197, 180, because really that's what we need to achieve here. We need that, and then also the streamlining element where we don't spend years with an application just sitting there in front of us because somebody hasn't achieved what we need in order to legally take that action to approve. Great.
Yeah, good morning. Greg Capillas, Pacific Hydrogeology, representing Oregon Groundwater Association. This discussion reminds me of a situation I ran into recently where we were applying for a groundwater permit for a church in Molalla. So we had to get land use form signed by the city of Molalla, which was something I don't think they were very familiar with. I mean, most of the time I just deal with counties, for ag activities. But in this case, it was kind of a different situation. The city wasn't able to, they were conflating, I think, getting the building permits, so this was for a ballpark, basically, that the church wants to develop. And the city did have in their comprehensive plan, they did have language in there that expressly allowed the use of a well for irrigation. And but nevertheless, they weren't able to kind of wrap their brain around the fact that all they really needed to do was say, yes, this is in compliance with our comprehensive plan. They kind of conflated, I think, the need to get the building permits to actually build the ballpark. And it really caused us some problems here. And I think really all they really needed to do was acknowledge that, yes, this is in compliance with our comprehensive plan. And I'm just wondering if there's some way to make the language in the rules here a little bit clearer that that's really all it's asking for.
Yeah, Greg, that's a really interesting comment. Thank you. So I think if there's an opportunity to add language to clarify things for the local government, it would best be in the land use information form, because they're not necessarily sitting there looking at our Division 310, they're looking at the land use information form, but that's an interesting idea. So they're going to be looking at if the land use for which water is proposed to be used is consistent with the applicable acknowledged comprehensive plan. So they are looking at the land use itself, not necessarily the water element. So for example, somebody's applying for water for irrigation. Well, irrigation for farm use is the actual land use. Somebody's requesting water from us, but the actual land use is farming. So they're looking at, okay, is this EFU land? Farming is allowable use outright. They would be checking the part of the form that says it is allowed outright. And so, you know, we can evaluate, Greg, if there's an opportunity on our land use information form to make things a little clearer for the local governments, to make it real fast, efficient development form.
Thank you.
Sounds like we're gonna need to have a lot more conversation on land use, so I'm gonna just note that for the whole group. And I think there's been some great points here that I am not a land use person, by the way. I chose water. Water is hard enough, right? But I do think there's some follow-up we need to do in terms of, well, we can talk more about it offline, but, so I do want to note that I'm hearing you all. And so I think there's some additional digging we need to do. And I do see we've got two folks that want to talk about this more. So, and then I think we need to wrap up this topic for the day. Noting that we promise to come back to it, so.
Thank you, Raquel. Christopher, please go ahead.
Good morning. So it's well known that comprehensive plans across the state of Oregon are out of consistency with the statewide planning goals that DCLD manages. And in fact, there may be more comprehensive plans that are out of sequence and out of sync with the planning goals than there are that are consistent. And so I get the impression that OWRD is kind of rolling over on its back and submissively responding to comprehensive plans by political subdivisions without regard or without acknowledging that they probably aren't consistent, that they probably, you know, that OWRD may not or should not be complying with those comprehensive plans because they're inconsistent. And I'll note that the SAC, the OWRD SAC mentions, quote, that the LCDC rules generally require state agencies to comply with the goals, which are the 19 planning goals, by achieving compatibility with comprehensive plans. But the assumption is that those plans are actually legitimate. Under certain circumstances, and these circumstances are when those are illegitimate plans, agencies may find actions in compliance directly with the goals. And so if OWRD goes to comply with a comprehensive plan that is not good, then I understand this as that then OWRD is supposed to go directly to the goals and in fact bring the comprehensive plans along and force the comprehensive plans to comply with the goals before OWRD takes action. And the other thought or question I had is that I know that OWRD is planning on updating its SAC from like 1990. And I wonder if that has to happen or if these rules are telegraphing any changes to that process and what the cart before the horse happens in this regard. Thank you so much.
Thank you, Christopher. Appreciate it. Lauren.
So I was just gonna suggest, and maybe Michael or Brandon could help with the language, based off what Greg said. If there's a way you can put language in this, it's just because the local government is saying it currently complies with our comprehensive plan, doesn't mean that they're being held to a
approving that land use process. It's still gonna go through it separately, but they're gonna say, hey. Yeah, I mean, cause I think that there's some fear probably that if we check yes, now we're required to approve that land use. And so if there's a way that you can just let that, maybe they have some language to give them a little relief that that's not necessarily the case, and the land use process will happen in the land use process, and the water right process will handle in the water right process, and that way they can just both move concurrently and not slow things down.
April, or actually, I'm sorry, I don't know who was first.
Well, JR put it up and then put it back down, but I do think, because there are several folks in here that do have more experience with this than I do, but I think just generally speaking, this is a change that doesn't seem to be driven by the core reason that we're here doing this rulemaking, which we have a lot to do. So I'm just going to posit that this may be one that is not necessarily appropriate to change through this rulemaking unless, I mean, we already have a very robust schedule, to say the least. And so I hear the concerns by my municipal brethren, but I also have some concerns just on my own when we are changing something that has a lot of potential implications. So I think we need to be really careful about things that are not clearly driven by the two bills particularly, which themselves have issues, so.
Yeah, I appreciate your comment, April, and the focus on our goals here. So I do want to reassure you that this is actually very much also a streamlining element here. It can take us years hung up in the process trying to get the information we need to comply with ORS 197, 180. And as you know, we have backlogs. We need to get those backlogs down. We are driven to reduce processing times. So when we see something that has, and land use has repeatedly been one of those items where we get stuck in the process because we don't have the information we need to comply with 197, 180. So this is to address it where we would have the information we need at the start. That is what should constitute a complete application. We have all the information we need to do our review, and then the review moves more quickly. But I really appreciate that, April, just kind of grounding us. And if I'm not clear or we're not clear when we're discussing rules about the goal, thank you for giving me the opportunity to explain that.
Okay, we're gonna go to Michael and then we are going, Brandon, Michael and Brandon, and then we're gonna stop talking about this particular one. We've heard you. Thank you, April, but we need to sort through what we do with this next. If you do have additional thoughts on this, preferably solutions, folks, help us fix this issue. We'd love to hear more about it, but I do want to make sure we don't spend the whole meeting on land use, especially since we're not experts in land use. So, Michael and then Brandon, and then we're going to close out this particular topic.
Okay, yeah, thank you, Raquel. And it's, I do want to say I appreciate that you hear this and, really underscore the point. I mean, part of the reason that I'm bringing it up is that I want to underscore land use is part of the overall project permitting for us in municipalities. So, I know while we're focused on water, the part of bringing this up is just to underscore that when we go out for debt on a project, and, I'm going to be happy to, work with our folks and provide some language, is that this could be very, problematic in terms of getting those projects. And, maybe just a rhetorical questions like, who are comp plan, what comp plans, what agency approves comp plans? I mean, I think that would be, a nice level setting thing as well. So that's it. Happy to provide more comment. Thank you.
Michael, I'm sure you all are probably working with your attorneys. So just to put the ball a little bit in your court, I'd be curious to hear what they think is a solution for ensuring that OWRD is meeting the requirements of the law while also accommodating the concerns that you all have. I'm sure there's a ground there. So, we'll do our best work to try to sort through that more, but I would ask if you all can put your best people to think about that. that would also be helpful. Let's go to Brandon and then we are gonna wrap up this land use piece here. Thank you.
Thank you. Appreciate the opportunity. I was primarily going to agree with Lauren there. Maybe Michael and I can put our heads together, come up with something here if we do in fact need to make a change to sub L. And then I feel as though I would be remiss if I did not say that all city and county comprehensive plans have to be approved by LCDC and the folks over at the land use agency. So for what that's worth, thank you.
Thanks, Brandon. Yep, that's why we've got the word acknowledged comprehensive plan in there. The acknowledged parts, to your point.
So Brandon, I'm gonna take you up on Lauren's offer of your time and Michael's offer of your time. So I will offer the same to you as I just offered to Michael, which is we'd love to see what you all could put together. And yes, to your point, you know, we're all trying to just follow the law here. And WRD is not the approver of comprehensive plans. And so we do need to rely on what other folks have already approved. So thank you for noting that as well. We are done with this. Kimberly, okay, get your word in.
I don't have anything specific to say, except for I do know there are some conservation groups that are interested in the land use water connection. So that's not my specialty, but maybe I'll circle with them and circle back.
Okay.
Thank you.
Thank you all for a robust conversation. We appreciate it.
Well, and if anybody wasn't awake before, you sure are now, so this is good. Jeff got us started and now, with your good energy this
Everybody has
morning,
a role.
everybody does.
So just so y'all know, Jeff has a strong preference for people online to show their faces. So he wanted folks to be aware of that this morning. So if you hear a little outburst over here, it was a preference to see your faces, at least particularly when you're commenting, so.
Okay, thank you. So, we do have two other rule divisions to get through and we're only on page 4 of 310. So, if I'm going too fast, please tell me to slow down. But we do need to move through, fairly quickly. So, we're still in application completeness. There's an item requiring somebody to provide evidence that they have authority to assign on behalf of, trusts, organizations, or other entities. That makes sense. From our perspective, to know that they've got that authority to apply on behalf of somebody else. We've struck a requirement related to groundwater applications because we confirmed with our groundwater section that we already have that information through other means for applications from here on out, so we don't need that anymore. That's a streamlining effort. Scrolling down, we've got clarification around the types of information we need for smaller reservoirs. We realized customers were having, you know, some challenges understanding something that frankly, I wouldn't understand intuitively either, crest width. So we talked with field services, dam safety, and we had clarification on what information we really need to assess their activities. Kimberly.
I guess I'll just note that we do have a concern with that because some of these reservoirs are huge. I mean, they may seem like they're small, but there was one, Glenn, you probably know the one in the Klamath that was like over 100,000 acre feet because it was really long.
That can happen.
So we do have concerns about removing this if we think it's valuable, but
Okay,
we'll put it
yeah,
out.
it'd be interesting comments. Thank you. All right, maps prepared by CWEs should also be signed and stamped. That's pretty evident. That's what they do already. Moving forward, we have language. This is getting at House Bill 3342 implementation. We're going to make it clear to people what portion of the application fee needs to come in at the front end, and then what portion needs to come in after the initial review should they decide to proceed. And then last item we have under application completeness. So this may look a little unfamiliar to some folks. This is Senate Bill 1154 implementation. And so this is almost directly from statute. It's pretty much verbatim where you're going to see this come up in 310. So these aren't policy decisions here or process improvements. This is a statutory implementation. And so where folks are abandoning wells due to groundwater quality issues in groundwater management areas and substituting them with group domestic use expanded through a public water system. then there's certain information we need to show that they qualify for going through a streamlined process. Looks like Greg has a comment.
Yeah, thanks. It's it's more a question, really. I guess when I was reviewing the bill, I saw a lot of references to this and really wasn't very clear on it. So I think you just sort of clarified it for me in part, but I just want to make sure I understand. So this is just a situation where you would have wells, domestic wells, I'm assuming, abandoned because of water quality issues, because they're in a water quality concern area. And this would give a green light basically to a permit for like a group domestic type of or a group domestic permit to serve those homes that were previously being using individual domestic wells. Is that right?
That's generally correct, Greg. So it's a little bit broader in the references you see there in statute exempt uses. I think that would generally be the situation, but there's a reference to the exempt use of single or group domestic purposes in an amount not exceeding 15,000 gallons per day. If used by a household, so you see, I'm not the folks in the legislature, who could speak to the exact intent there, but I see that 1D is what I just read off, and then we look at the next one, if used by a household. It's strictly speculation if sub A there is for something broader than if used by a household, but the if used by a household does also reference to the part of our exempt water use, which is watering any lawn or non-commercial garden not exceeding 1/2 acre in area. So if it's a well that's being given up from a household that was using what we call domestic use expanded, so they're using water in the house and then a limited amount of water outside for specific purposes, then that would fall within the types of abandoned wells that could be substituted for this group, or that could be substituted out by the group domestic use expanded system from the public water system.
Okay, thank you.
Go ahead, Jayla.
Yeah, so, I mean, we use the term generally a lot, abandonment or abandoned is so, and this is just from base and experience, but is there a way we can reference the well abandonment program or rules within that? Because again, people need to get used to there's a formal process for abandoning a well, not just saying I'm not using it anymore, especially if the well is poorly constructed, et cetera. And I'm just saying that the term abandoned versus, the procedures for formally abandoning a well, they're confused by the general public. And I think that we need to start, really pushing people to legally abandon their wells rather than just not pump them. So.
Thank you. I think Director Gall has.
We've used or permanently abandoned in the past to denote the difference between kind of a temporary abandonment where you can weld a steel cap on it and walk away forever versus permanent abandonment, which is to properly abandon it under the terms and conditions of the well construction.
Yeah, and I'm just saying, in here, it's being abandoned, but it doesn't say pursuant to, the procedures for abandoning. And I'm just, if anytime that there's a proper procedure for doing something, I'm wondering if we should reference that in here, because are you proposing in here that in the new language that it's being, properly abandoned pursuant to your procedures, or is it just being, is that left up to the landowner that I'm abandoning it? I mean, that's the question, I guess.
That's an excellent point and an excellent question. So this is verbatim from Senate Bill 1154, but that's a longer bill than just what applies to Division 310 water transactions.
Okay.
So that may be defined in there, but we can take a look.
Okay, yeah, that's the only thing if that word sometimes.
Yeah.
Used on a regular basis, so. Thanks.
Moving forward, we have a reference to our standard map criteria in Division 305. We've talked about that before. Currently no supplemental requirements are placed in 310 because everything that we believe we need at this time is in our new mapping standards on 305. Okay, moving on to 0070 completeness review. Laura for driving there. Okay, so here we get into 3342 implementation. So this is not discretionary. There's a few other items in here, but the 3342 elements are reflecting the phased application processing. We look to see if folks have submitted a complete application and the portion of the examination fees that we need, because under the new statute, we don't need to collect all the fees upfront. So you'll see that language change there to reflect a portion of the examination fees. Next item, suitable book. I think we used to have an actual book. Ivan, you may know if that's the case, but nowadays all that information is easily available to the public. So we're defining a suitable book to include our electronic water right information system, as most folks know that is RIS.
The reason that we're still using the word book is because it's in statute. And yes, there did used to be a book. There's different ways you can define book though. So we want to make it clear, we're not writing it down in a little book by hand.
Hey, books are awesome.
Books are awesome. Not when you need to search them.
And then the last parts here in this rule section 070 are House Bill 3342 implementation. And so that compels us to send back applications under certain circumstances. So we would just close, or we would send back the application, we'd explain why, we'd send back any of the fees that were paid. Right now we do that, and we're statutorily required to do that. If somebody is requesting to appropriate water from an ORS 538 withdrawn area, and so Multnomah Falls, for example, we're not going to be appropriating water from Multnomah Falls. So that's protected. That's the type of water resource protected under 538. So right now, our process is already to send those applications back, send the fees back, and explain why we're doing that. What the House bill did is it expanded the set of applications that we send back. And really it's to give people, well, I might imagine some of the intent would be to give people the courtesy of a quick answer, right? If they're not going to succeed getting through the application process, it's much nicer for them, I think, probably to get that answer quickly and to not have to have paid fees for an application, rather than for us to be compelled to process the application through at least the initial review period, to have used some of that money, only to tell people, I'm sorry, but this area or this water source is withdrawn by rule or order of the Water Resource Commission, and so we can't allocate it. Or in the case of groundwater, if the source of water is designated as a critical groundwater area, subject to restrictions on allowed groundwater uses by, and you can scroll down more there, please. By classification, so that may be in our basin rules, or withdrawn from appropriation under ORS chapter 538. So if there's groundwater that's hydraulically connected to surface water and you would appropriate a surface water source withdrawn by chapter ORS 538, or otherwise by rule or order of the Water Resources Commission. If we know it at the time the application comes in the door, we're going to send it back. So this is strictly an implementation item. This is not discretionary for us. April.
May or may not be the right time to bring it up, but here I am. Just want to bring up, or a thought, I don't know if you guys have considered, as you start to move to accepting payments by credit card and passing that processing fee on to the person paying that, generally the systems for that, if you refund the fee, you're not going to get the processing fee back. Is that something you guys have thought about? If not, I would encourage you to make sure that there's an ability to, I guess, let the person know that if they were to get a refund, they're only gonna get the refund minus the processing fee. But there's potentially also a processing fee when you refund it, depending on what type of merchant you guys are using. And, I wouldn't want us to learn that departments has a massive deficit because they've had to refund a whole bunch of fees and then eat the processing fee or pay more processing. Does that make sense?
Yes, thank you. I really appreciate that. That's very forward looking too.
And that probably applies across a variety of things, but particularly in these ones where we're gonna let people know and refund their money, that I think is an important consideration.
Yeah, thank you so much. Mark?
Good morning. I just have a quick off-the-cuff question on this. If a applicant decides to write a check, no processing fee would be applied. Is that correct?
That's correct.
Okay. The reason I ask is DEQ has a process that was recently approved that requires a processing fee regardless of the type of payment. And I want to make damn sure that that is not occurring at the Water Resources Department. So thank you for that answer, and I appreciate the response.
Very welcome.
Mark, I think the statute that we also passed related to processing fees, it only allows us to pass on the fee. It doesn't allow us to create a new, revenue source.
That's right.
Thanks for that, Raquel. I appreciate it.
Austin?
Yeah, I have a just a minor comment regarding subsection 4 and 5. I'm just curious why the language is a little bit different in the first sentence regarding groundwater and surface water.
Yeah, so great question, Austin. In 3342, the bill breaks it out based on if it's an application for use or storage of surface water. We have certain restrictions, and then if it's an application for groundwater. So for example, if it's if the request is to use surface water, then we're not going to need to look at if it's designated as a critical groundwater area, right? That wouldn't apply. So it's broken out that way just to make it really clear for people based on the type of application you're applying for.
Thank you.
And maybe I can add a little bit to that too, because that's some of the changes we asked for. Originally, the bill language was tied to place of use, which was problematic in critical groundwater areas such as ours, where we're trying to use available surface water to take pressures off of groundwater place of use boundaries. This is what prevented us from doing that. So that's why we asked for it to be separated in the bill.
Really?
Yeah, this is a small point. I'm trying to find it in statute, but just a flag. It seems like there's a little bit of a sequencing issue. It seems like it would be more expedient if after determining it was complete and the fees were provided, that you then looked at this new requirement rather than first endorsing the application. Because so in one, you're receiving the application, and two, if it's complete and has the fees, then you endorse it, and then you move into the other analysis. I guess just flagging, there might be a sequencing problem, and just a reminder that I think one of the purposes of this section was to help cut back on litigation, and it's unclear to me if you endorse it, if you sort of open a loophole for you guys. I don't think that was, the intent was if there were these closed areas, you guys wouldn't accept the applications, and it seems like there's maybe more process here than we need.
Yeah, I can see that point, Kimberly. I think that's the order it may be laid out in statute. If our folks receive something and it's really clearly in a critical groundwater area and we can't accept it, I don't know how closely they would need to be looking at the map, right? They see there's a map received, but in terms of some of the finer details, I don't know that they would need to spend a lot of time on that if it's clearly something that we can't accept. Does that make sense?
Yeah, it does make
Yeah.
sense. I guess I just would ask when you're reviewing this, and I'll put it in written this,
Yeah.
what the action of endorsing means when someone submits an application, and if the ordering here sort of undermines.
Okay,
But then
yeah,
again, I need to cross check with the statute.
yeah, we get to look at that. Thank you so much. Okay. Okay, moving into 0080 initial
Chris.
review. Oh, sure, Chris, go ahead.
Yes, thank you. Can you help me understand this kind of dangling clause at the top of page 10 under under section 5, where it says, if the department has information sufficient to make the determination at the time of the application intake? And can you, in that explanation, share what if the department doesn't have information sufficient to make the determination at the time of the application intake? And lastly, how closely does this rhyme with the water availability issue in Division 300 definitions? What is it? 300 and subsection 57. Can you let me know what you think about that and what that is?
Yeah, sure. Thank you, Chris. So I'll give one example of, where the phrase, if the department has information sufficient to make the determination at that time of application intake applied. So for example, if we receive a groundwater application, it hasn't gone through the groundwater section's review yet, so we don't have their determination on if there's hydraulic connectivity to a surface water source or what that surface water source is. Therefore, we don't necessarily have the information at time of intake to know if the groundwater, requested groundwater appropriation would impact a source of water withdrawn under ORS 538. So that's one example where that information, where that language really applies. And then in terms of water availability, we wouldn't be doing a water availability analysis here, but obviously, I mean, that would be later on in the process, but obviously if it's a critical groundwater area, there's known groundwater availability issues. Thank you. Okay, moving quickly, 0080 initial review. You'll see there's a reference there, except for applications described in 530 ORS 537 615 sub 7. That's referring to Senate Bill 1154 that we talked about, those community water systems that would be replacing abandoned wells. We don't need to do a water availability analysis in the initial review. This is statutory implementation right here. We also have additional statutory implementation for allowing us to communicate through electronic means. The applicant has 90 days from the date we send the initial review to notify us if they want to stop processing or proceed with the application. If they don't provide us notification and pay remaining fees, we close the application file and take no further action. So that is strictly an implementation item.
So can I ask a question there? So we may have people who are not used to applying for these. They may not seek the counsel of someone. Is there an intermittent thing saying, hey, you haven't paid anything, we haven't heard from you? I'm just trying to think of the person who is just not used to the process. Maybe this is their first time dealing with a state agency. I'm not asking for additional steps, but I'm just curious about if there's a sensitivity towards that.
Well, Jeff, that's a great implementation question that we need to think about. So we will be notifying them, and then our initial reviews we're pretty descriptive at this point, laying out people's options. And then they have 90 days. So right now they only have 14 days to make a stop processing decision. This gives them 90 days to make a decision to proceed or not proceed.
The only thing I would suggest is in the subject line, make it clear that they need to respond, because I'll tell you that I can't get my growers' attention unless I put it into the subject line that I need your response by X.
Yes.
Because that way they'll pay attention. I mean, I love my people.
People are busy.
But they don't, they come in after being on the tractor all day and having to deal with all this stuff that, So it's just a friendly suggestion.
Yeah, I appreciate that. Thank you. Leah.
I actually I definitely want to agree with that suggestion, because I think that in a lot of cases when people have previously applied, they only need to notify you in writing to stop processing. But if they don't notify you, then, you know, it goes on because you assume like, all right, it was a great initial review. Of course I want you to process it. Now that they have to do something to continue the process, I think that's really important to make it clear to the applicants that they need to take action regardless of whether they want you to stop or continue processing. I think that's really important. I also wanted to check, is there any way, if the 90 days expires, is there any way to reopen that? Or is that 90 days like a very hard deadline and there's nothing that can be done on the 91st day?
Great question, Leah. This is statutory, so it says if they don't take that action within 90 days, then the department shall close the application file and take no further action. So we're done at that point.
Okay, so, and I haven't checked the statute, but is that the same? Should I just assume that for all of the deadlines that are in this division? Like, you know, after 15 days, OWRD will provide this. You'll do that, I'll do this. Are those all very hard deadlines?
The specific part that we're talking about here is, yeah, so we're about 90 days. That's specific to statute.
Thank you.
Yeah. April.
So a couple things, want to agree with the statements made, and I do think, switching to this process is going to be an adjustment. So while the 90 days is a hard deadline, what you guys do up until that point, I do think there's some flexibility there. And I guess, this section may work better if it was broken up a little bit. I think just from reading it as well as understanding it, particularly, as Leah said, because this is a departure as far as there needing to be a notification to proceed and also the paying the remaining portion of the fee. And as we all know, while hopefully email will be a bit more reliable than regular mail, there's still some issues with that. So I think there may need to be some additional notification or something that helps there. But the other thing that I was thinking when I was reading it, just to be clear, so someone would be paying part of the fee that would be for the initial review. If they don't notify the department that they want to proceed or don't pay the remaining fee, the department gets to keep the fees that have been paid up until that point.
That's why it's phase fee processing, or phase fee payment, because it pays for our review to get through application completeness, to get through if there's a groundwater review involved, a well construction compliance review, and our development of the initial review. So that first payment that comes in the door of the application gets us through that process. And that's why there's no refund, because ordinarily, you know, under the current process, we've only done a portion of the work. We haven't prepared the PFO yet or the FO. And so if people withdraw during the stop processing window, they get some portion of their monies back. With the phase fee payment, it's paying for us to get through the IR. We get through the IR, and if they can proceed, they pay for the rest of the review.
So it's essentially the same as it is today to some extent. It's just we don't have to take an additional step to refund the money, right? Because they paid the full fee instead of paying the portion.
Yeah, I understand that, and I kind of wanted you guys to say that out loud for other folks as well, but I think this is gonna require a lot of education for folks, both here and in other places, to make sure people understand the nature of the phase process, the nature of the phase payments, what their recourse is going to be if they disagree with any of those things along the way, because that's another thing, I think, that this potentially there's things that can happen along the way that aren't necessarily there being a denial or anything by the department, but something that gets lost in translation and the person didn't know or didn't, you know, pay or let somebody know, and then all of a sudden they're done, which I assume means they're gonna have to start all over again, pay a new fee, pay a new review, do all that stuff. And I don't think that's the intent of the legislation or what you guys are trying to do. It's just, I think, one of those things we just need to be careful of as we're doing this.
Yeah, I appreciate all the comments that folks are sharing about implementation, so we can be thinking of that as we head towards implementation. I'm going to confer with my co-sponsor here because we are only on Well, on my PDF, page 15 out of 39, just as a reminder, we are also scheduled to do Division 315 and Division 18 today. Unless you guys want us to add an additional RAC meeting, which I think with 7 of them, you probably don't, but I can't speak for you. So, wanted to discuss with you any ideas for getting us through this more quickly, or if we should just keep going. A lot of these are 3544 implementation and they're not discretionary, so I could just say that when.
You do have a question, that's probably on that you're talking, I think that's it.
Okay. Christopher.
Yeah, actually, in the spirit of wanting to move forward, my question is still back with subsection 5 in 070. And I wanted to wait until we were done with this section to just raise one more question.
Okay, go ahead.
Great. So would this subsection 5 still mean the same thing if the portion that says if the department has information sufficient to make the determination at the time of application intake, if that were moved up to the top where it would say, if a groundwater application is complete and not defective, and if the department has information sufficient to make the determination at the time of the application and intake, then the department shall determine whether the proposed rule is prohibited and so forth. Can you let me know if that would maintain the same meaning of that? And if so, that would answer a lot of questions that I have. Thanks.
So Chris, you think it would be clearer if it was moved to the front? Is that
What,
basically?
I'm actually asking you that question.
So, we can take a look at that. The concept here is that, so yes, it applies to all of those pieces as it relates to the classifications, the withdrawals, and the, what is it, critical groundwater areas. The idea here is this should be, if the front office staff can't figure it out quickly, right? That we move on and move it forward in the process. If it's very evident, then it's a quick, sorry, this application's returned. So that's the whole concept in this legislation, if that is helpful to you in understanding the intent here.
Well, I'm familiar with the legislation. I provided extensive comments on it. I just thought that putting the if at the end of this sentence made it ambiguous, and I wasn't sure if putting it up front would remove that ambiguity, at least for me.
So we'll make that note.
Okay.
We're gonna edit on the spot here, but we'll make the note and determine, if that makes sense. So I appreciate the suggestion. We'll take a look at it.
Thanks so much.
Thank you. Yeah.
Yeah, I just wanna, I'll put this in comments, and we're gonna probably have to wait until we get through all these to actually give you written comments, just because the bouncing back and forth is hard to clear. But I think one of the things that this really is highlighting is a lack of uniform, direct, interpretation at the local permit processing level across the board to really be able to engage in the process either as a consultant level, as a city staff level. And so my concern with these is that, again, the intent is for this to go this process. But is that intent going to be put into directives to the field offices and the permitting divisions? Because again, our local office's interpretation may be completely different than what you guys are thinking. And at times it's confirming for me, it is completely different. And if this is just gonna get returned with no recourse at the point of, we're just returning the application, you don't have a right to protest, you don't have a right to appeal, then you're completely beholden to a local person's interpretation of what they think is the right way to go. And that's a problem. I think that's the underlying, I know that we've got legislative directive here, but there's some major implementation issues with that deference to, the local office.
I'm not necessarily seeing what you mean by the
Well, 'cause you're
involvement of
saying-
the local office. This
You're
is-
saying, okay, go ahead.
This is really, sorry, so maybe I shouldn't have said front desk person, maybe that's where the confusion is coming in. Cause I don't think we're talking about the front desk folks. If an application is dropped off at a local office, they're not gonna be doing that initial intake review. It will still go to someone in the water rates section that will be responsible for doing that initial intake review. Is that how you're kind of envisioning it?
Yeah,
In
the
Salem.
folks in Salem are in the Water Rights Services Division are the ones who receive applications and then do that evaluation if we were referring to the withdrawn sources. But they do, the full completeness review. Now, folks in our field offices are a great asset and do try and answer questions for folks. But I think what I'm hearing from you, JR, and you can correct me if I'm wrong, is that as part of implementation, just making sure that we're communicating with our folks in the field services division so that they also understand these changes. And then they're in a better position if someone comes in with a question to help answer it or to know that that's something to redirect to our division in water rights services.
Yeah, and even in the Salem, and again, we don't need to belabor this today, but I think I'm just wanting to highlight the issue that I see coming up is that there is and we all know this, very diverse and nuanced interests, in both the problem and in the solutions in these various basins. And who's making that ultimate, who's getting educated in Salem on our specific issues with our curtailments and everything else in the critical groundwater areas of Umatilla Basin versus the Klamath versus other places, because each of those have different structures and structural solutions and structural reasoning for new permits, et cetera. And my concern is that if the initial review is completely left to them to say, based on our, interpretation of, best available information, we're gonna proceed or not proceed with the application, and there's no right by the applicant or the region to, agree with, or we just get the notice from you that we're sending this back because we don't think this is worth doing. And trying not to put words in your mouth, but that in our mind, that's what it happens. Then there's some real implementation structural issues we've got to get through, because who's creating that education? Who's getting that person educated on that basin's issues and why these applications will be coming,
So JR,
I'm just struggling with that, so.
I wanna make sure that we're all understanding the process, and Katie, if I get it wrong, tell me I just got it wrong. So we received the application, right? There's that initial completeness review, and is it in a withdrawn area, which we can't approve that anyways, right? If it's in a restrictively classified area, we can't approve that anyways, right? Or if it is in a critical groundwater area, and it's a groundwater, right? So I didn't get into the nuance whether it's surface or groundwater, right? So those are the three things that we will look at. Because if we keep processing it, your answer is still no. Your answer is no, 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 all the way through the process, right? So it doesn't matter at the end of the day who looks at it, the answer is gonna be no from that standpoint, right? So that's what we're trying to give folks an answer up front that says, hey, this isn't allowed. We don't want you spending your money on it and return it, right? So that's the first step, right? Once it gets through that part of the process, then it goes over, let's say that first review, they don't find anything, right? Then it goes over to the caseworker. That goes through the initial review process. That will include, if it's a groundwater application, that will include the groundwater review, right? That our hydrogeologists look at, and our water master review.
And I'll pause there. The water master review happens after the initial review stage
Okay.
for new water
I
application.
knew I was gonna get one of them wrong, so.
Everything else is right.
So it does at least include the groundwater review, right? And so then you get the initial review, and the initial review will say, here's our findings on these 4 things. She's still nodding yes. Wow, okay. And that's like water availability, that's the additional review of whether it's allowed in the basin program.
Injury and other rules of the commission.
Okay, so it gives you that initial look. So then that tells you, based on our initial review, it's likely this will be approved or it's likely this will be denied. And so that's the next step of the process. And then the applicant has an opportunity to provide feedback, right, on that. And to say like, hey, I want to keep going. And that's when they have to pay more if they want to keep going, or nope, want to cut my losses. And just, I've already paid for this portion of the application, I don't want to pay more, right? So then they go through that and let's say they don't want to keep going, then the process is done, file's closed. They do want to keep going, they pay the additional fee, and then that's when they get the proposed final order. Okay, the proposed final order is then the basis for them to protest. So that's the full picture of the process, if that is helpful. That little piece there at the beginning is really to give these clear-cut cases where it's like, do you want your money back? Because this doesn't have a chance of getting approved based on these three criteria here. Does that make sense?
But you're not saying, do you want your money back? You're giving them the money back.
Yeah, yes.
Yeah, so you're not asking them
yeah.
at that point. You're
Yes,
just saying, we're
that's
giving you your
correct.
money back. We
Yes.
made the interpretation. And that's what I'm saying is that, well, we can, I can talk to her about this stuff.
I think then talk with our staff, and if we're wrong, you keep having, then you refile, right? But so we can talk more about the implementation. I hear you on that part, but that's the snippet in the process, right? Okay,
Mostly nothing.
I'll remind folks that this part is in the statute too, so there's only so much that this group can do on this.
Yes, yeah, this is implementation only. Austin?
Yeah, I just wanted to make sure I understand it correct. I know we've spent a lot of time on this section, but in terms of an application that's defective by nature or there's deficiencies present, which result in a unfavorable initial review, during this part of the process, can the applicant file an administrative hold to rectify the issues that were identified in the initial review before paying the additional fees to continue the application or the process?
No, that's a great question, though, Austin. So the following strictly what's in the statute, they have 90 days to make a decision to proceed or not. There's nothing built in there about allowing for admin holds. So that would be after they decide, I want to continue to proceed, and they've paid the remaining portion of the examination fees. Maybe they're concerned about us moving forward with a proposed final order to deny or with conditions that they're really concerned about. So they might request an administrative hold at that point, but it doesn't stay the 90-day clock here.
Okay, great, thank you.
Great question.
So one thing I think I'm hearing from this, which I appreciate, is that we probably need to consult, when we move towards implementation, we probably need to consult all of you on some of our communications and materials to make it clear how this is all gonna work, right? So I do think this has been helpful to hear, the concerns here about how folks might interpret this. So I think we'll have to put that as a note for when we move into out of the rules and into the rest of the process, that we still need to check in with folks.
Great.
Yeah, hi, Greg Capillas here. So yeah, Austin actually raised a good point. When we request administrative holds, it typically is after just immediately or very near after the initial review. Because at that point, basically the record is open, or I guess we're allowed to at that point to maybe address issues that were raised in the groundwater review that we disagree with. We want to have the opportunity to provide some additional information for the groundwater section to review. So typically, and sometimes we need more time to gather that information. Now, of course, this 90 days now that's in the new rules, that will provide us with a bigger window than we now have. But I mean, I don't see anything in the old rules that precluded us from requesting an administrative hold upon issuance of the initial review. And I don't see that any of the new language would also preclude that. But from what I'm hearing is that you're saying, no, you can't request an 180-day administrative hold after the initial review. Is that correct?
To clarify, thank you for asking that question. So to clarify, there is still an admin hold process. It doesn't stay this 90-day clock, which I think is what Austin was asking about. And so if the applicant tells us we want to proceed, they pay the remaining portion of the examination fees, then they can request an administrative hold. So we still have that portion in our rules, but they first need to elect to proceed with the application.
Okay, great. Thank you.
Yeah, thank you. All right, moving forward. So I think we are now at 100. This is strictly 3344, House Bill 3344 implementation related to partial payment and electronic documentation, not discretionary. 0110, public interest presumption. That's simply updating a citation in statute that was changed through last session. And then going to 0120, public interest review for surface water. So that's just moving, taking out language that we have in other parts of the rules now. So as we've discussed, we already have a process above for what the applicant can do after we issue the initial review. So we're not reiterating in these rules anymore. We're updating a statutory reference. And then we also, we've removed sub 7 because that's covered in 0160, and that has to do with our contested case process. So that's covered elsewhere in our rules. Christopher.
Yes, I have a quick question with 090. We could scroll up to that. Let's see here, subsection 2A, and it says the affected local, state, and federal agencies, including planning departments of affected local governments. And then the section is struck out with a request that the copy of said notice be posted in a conspicuous location.
Yes.
Can you give me just a very clear explanation as to how this benefits OWRD and how this benefits the public and how this benefits applicants and any other parties?
Absolutely, Christopher. Thank you. So in the spirit of moving towards electronic documentation, it only seemed fair for our partners at other agencies, including local governments, that we're not asking them to print out every single one of the notices that we send them and post it somewhere around their building. We do hundreds of transactions every year, and so it didn't seem reasonable to be asking local governments and other agencies to print out every single notice. But also, everybody has access to our weekly public notice, really easy to sign up for. Pretty sure everybody in this room is on it. Anyone in the public can register for it and get that delivered directly to the email box.
Okay, well, what's interesting is that it hadn't occurred to me that posting meant paper. I thought posting meant like, in the 21st century, it meant posting online and it posting electronically. So I'm still, that question I have is outstanding as to how this benefits OWRD. And then I also want to make a very clear statement that there's a difference between having something like an Easter egg hunt where, there's some information that the average member of the public would have to somehow know to go look for. Whereas if it were posted electronically on, agency or affected local government websites, that they might actually be able to find it or they might be alerted to it. I mean, we're not necessarily saying do press releases, but the difference between having some activity occur and then just letting the public stumble upon it versus putting out a press release is a very different reality. The press release is actually proactively reaching out to the public. So again, my question stands, how is it that restraining or restricting this proactive outreach benefits OWRD and the public and these agencies?
So Chris, this isn't restricting or restraining. I want to be clear on that. The
Okay.
local government can still do that. There's no prohibition in this rule. I will look to, I'm curious, actually. So Brandon and Michael, you've won the jackpot because I'd like to ask a question if you're willing here, about, I suspect this language came from back in the day when public notices were only posted at the local county office or within the city, right? That's what I suspect. Whether it's true or not, I don't know. But I'm curious if counties still have locations where they post this kind of stuff in their local offices. I feel like I used to go into local government offices 20 years ago and you would see these kinds of notices. And I'll be honest, I haven't been in a local government office, I don't think recently, to know if this is still something that they do. So I'm not seeing Brandon or Michael, but if they're
I'm
still
here.
on, curious to hear. There you are, Brandon. Do you know if this is still something that counties do?
I mean, technically, yes, I think we are required to still have like a posting board somewhere. Which department it's in obviously will vary county to county. We are desperately trying to get away from having to do some of those types of postings, like there's a number of statutes that require local governments to post in a newspaper of, right, and we're losing all of our community newspapers as an example. So trying to turn electronic as best or as fast as we can would be greatly appreciated for the local folks. And I don't want to speak for Michael, but at least on the county side.
Brandon, one other question. Is there a place, as you all move away from the in-office kind of postings, have counties created then posting boards where they put these notices, or like to replace that? Or is it just more that they're going, it's like a notice?
Yes, we have posting boards for like planning commission meetings, board of commissioner meetings, all of those types of things. We have designated web pages for those types of postings. So I mean, I don't see why we couldn't have a designated page for something like this also.
Okay, thank you.
And I deliberately turned my camera on for Jeff, so I hope he appreciated it.
Thanks, buddy.
Oh, there's Michael. Go ahead, Michael.
Oh, okay. Yeah, I just want to make sure. Yeah. I kind of understand generally we'll see like the physical postings at like a lot of our really small cities will have that, but I'd have to get back to you kind of on a wider like answer to that question, but at least just wanted to provide some of that context that we'll see those physical postings at our smaller cities. So
I guess, we could leave this language in because it just is a request, it's not a mandate, right? So if that is, maybe we just leave this language in, if we think it provides maybe a benefit. And maybe we massage the language just a little bit, but that might be a middle ground there. Yeah. Okay, we'll look into that. Thank you all.
Yes, and I just wanted to point out one more time that whenever we use the word posting, we're not talking about paper, right? We're talking about posting on the internet where there's widespread access. And just to contextualize my concerns, which I think are obvious, is that most of the 80 newspapers that are well functioning in the state of Oregon, a lot of them have an online presence, and that it's wrong to consider newspapers going out of style simply with regard to the print function. A lot of them have electronic functions, and And I think in general, I think we just need to acknowledge that the push at the statutory level was to streamline the process. And the best way to streamline the process is to minimize access of the public to the information that they might object to. And I think that's the wrong way to go about it. I made myself clear earlier when the statutory process was underway that restricting public awareness of water resource department actions is not the best way to streamline the process, you know, and I will stand by that. Thank you so much.
Thank you, Christopher. Okay, so we are now in 0150, and so what I'm heading into in this next part, I'm going to be very brief because this is non-discretionary for us. A number of the rules that I'm going to point to, and I will tell you explicitly which pieces of legislation we're implementing. And so let's see, we are under, well, actually, before we get to that one, we're under 0130. That is strictly a statutory implementation of Senate Bill 1154, streamlining the process for our evaluation of those requests to appropriate groundwater for public water systems that replace abandoned wells in groundwater quality, groundwater management areas. So not anything that we have discretion over, that's strictly implementation, pretty much verbatim from statute. And then 0140, so we've moved language from one part of our rules to other parts of our rules, so it's still in there, it's just in different locations now, and that's to help conform with our contested case legislation, where we put additional language in 0160. Moving into 0150, proposed final order. That has implementation for Senate Bill 1154. Again, that's streamlining those public water systems applications that meet certain requirements. And then 3544. And so this gets into the process for notifying folks of the proposed final order and deleting a reference to a deadline for an applicant to request a contested case hearing. That's different from the protest deadline. So that was removed under 3544 and we've removed it under our rules. Then we're going to look at 0160 through 0220. So those are all implementation of House Bill 3544. It gets at contested case processes, folks requesting or protesting a decision that we've reached, and then implementing the part of 3544 that would take a proposed final order and make it a final order by default if nobody protests and 33 days have passed from the protest period. Does anyone have any questions about those sections? Again, those aren't discretionary, that's strictly implementation. Okay. Moving into, oh, do you have something, April?
Which section are you moving into?
At 0230.
I guess just question, because we did go through that really fast.
Yes.
On 0160, but it comes up, I think, elsewhere. I know most of this is from statute. I don't have it right in front of me. Under, so page 22, 2A, the statement, and the director finds that there are no significant issues related to the proposed use of water. Is that lifted from statute?
I believe it is. Yeah, I think that's 3544. Those three options are, I believe, laid out there.
I'm trying to remember if that was something where that definition of no significant issues was defined.
So if you look at, it's gonna be in section. Give me 1 second, I'll just give you all the. It's in section 5A of House Bill 3544. And it is subsection 7. And it says, which I think is, let's see. It looks to me, based on quickly looking, that it's verbatim from the statute. So if you want to look at the statute,
That was,
3544,
that was just the response I was looking for.
5A7. Kimberly?
Somewhat related, I think in other sections, we're removing discretion, which we think is still in the statute. So just ask people to put that.
In Division 310?
Yes, yeah.
Okay.
So just as you're in those sections that you delete.
Okay, is that something that Water Watch intends to submit comments on?
Yeah.
Okay, great, thank you, that's up, appreciate it. Okay, and then 0230 is exceptions, and so we are proposing to repeal the outdated reference to department's hearing referee. We don't have one of those. That's handled by the Office of Administrative Hearings now. And the right to file exceptions and procedures for filing exceptions are addressed in OAR 137 and our OAR 690 Division 2. So those are now covered in, those are covered in those other rules. 0260 water rights within or above state scenic waterways. That's quickly a grammatical update, easy there. And then our last rule section in 310 is 0270 timelines. And so we were talking about administrative holds a bit earlier after we get through the initial review, after folks let us know that they want to proceed with an application and they pay any required remaining fees for the examination of the application. Then they have the opportunity under certain circumstances to request that we hold processing of the application. And by that, I mean that we wouldn't be issuing a proposed final order on the application. So sometimes folks want more time for discussions or to gather information before we release a PFO because they think that may impact the outcome of our proposed final order. We've got in statute and in our rules, the ability for folks to, they've got the ability to make that request, but our current rules don't really put parameters on that. And this here, April, because I really appreciate your point of why are we doing what we're doing? Why are we proposing what we're proposing? This here is a really important part of our streamlining effort. We have had applications that have sat on hold for over a decade because people have requested admin hold after admin hold after admin hold. And I think it's only fair for folks that we explain parameters of what is reasonable and necessary to extend out processing timelines. So this gets at particular scenarios where we thought through, that would be a reasonable and necessary purpose for extending out the processing timeline. So I wanted to open that up for questions. I think Kimberly's got one.
Yeah, I still see an unlimited, the way it's written, except upon a finding, it seems like there's still the ability to have an unlimited. administrative hold.
To address that, and I'd like to hear your thoughts. So we say the cumulative length of extensions requested through admin holds shall not exceed 180 days.
Except upon a finding.
And then to your point, under each one of those scenarios.
Oh, okay, I didn't see
Yeah.
that, okay.
Yeah, so we've got a time frame listed for each one of those, does
Sorry,
not
I didn't see
exceed.
that.
Yeah, to get to the issue you were pointing out.
And then actually, do you all have, I have not been able to find in statute where administrative holds are allowed. Do you guys have that offhand?
Yeah, I don't think they're called administrative holds in statute, which is probably why it's hard to search for. But it's discussion of, and we can get to the specific statute, but it's discussion of within 180 days after we issue the initial review, we are supposed to move to the next step of processing. And so what this allows for, oh yeah, go ahead.
So 537175, which is which is section 7 of House Bill 3544, has the latest language on that. And it says basically that we will do it within 180 days. Except at the request of the applicant, the department may extend the 180-day period set forth in this section for a reasonable period of time. And so that's what it says. Okay.
April.
Follow up, so does that define administrative hold?
Nope, that's all the statute says.
That's kind of our internal phrase, administrative hold. So we added the phrase administrative hold because that's what people are used to, is what we call it. Oh, Lauren, go ahead.
Yeah, so I have a question on D about land use approval, not exceed 1 year. I'm not a land use attorney, but I understand that sometimes, LUBA and all of that can take well over a year, and that's not under the control of the applicant to expedite a LUBA process or the land use appeals process. So I'm concerned about the 1 year, cap on that, for that reason.
Yeah, Lauren, that was, one of the things that I noted that we probably need to talk more about.
Yeah, we'd love any feedback on that
Intent
one.
on that one.
Okay.
Okay. And then otherwise, last item there is we've repealed language based on House Bill 3544 that removed some portions of statutes. We repealed them in rule as well. And that's Division 310. Christopher.
Yes, thanks. I'm looking at the paragraph E, collect annual high water level data sufficient to evaluate reasonable stable groundwater levels. And is that from essentially one well? Is that what we're talking about here?
So thank you for asking about that one. One of the challenges that folks face is if we don't have sufficient information to evaluate reasonably stable groundwater levels, the groundwater section may say, we cannot determine, it cannot be determined if the resource is over appropriated or not. So this one is specifically to address the matter of needing to collect data over 5 years if folks want to overcome the, we cannot determine over appropriation or not. And so we also build in more time than 5 years because we understand that folks may need time to find somebody to go out and drill a well and collect data. So I can't say if it's one well, if it's more than one well, depends on what the application is for and what the groundwater evaluation finds.
Yeah, I'm very familiar with the groundwater allocation rulemaking process that went on. So I'm familiar with that whole process you discussed. My question is whether or not this hold, as it were, that would go on for 7 years, is to determine whether the reasonably stable groundwater levels are going to be determined based on one well, or if the annual high water level data is going to be based more broadly. The annual high water level means the highest elevation static groundwater level that exists in a groundwater reservoir or a part thereof during a year. And so my question is, are we talking about a part thereof here, which is just one well, and making a determination that there are reasonably stable groundwater levels based on just one well level measurement, or will reasonably stable groundwater levels be determined over a 7-year period, not to exceed 7 years, more broadly? And I can imagine that it might serve a water user to just check their own well in some cases, and in some cases it might be advantageous to them to more broadly consider the reasonably stable groundwater levels within the single groundwater reservoir that they're in. And so I think the question I have is really, what's the scope here? Is it limited? And what the intention is. Thanks so much.
Thank you. Yeah, I don't know that I have all the details right now for you, Christopher, but it's intended to help them with their own particular application. So, you know, that data may be useful for future applications or just general data collection, if it, you know, helps our understanding of the aquifer system out there. But sub-E is specifically to help somebody with evaluation of their own application. Austin.
Yeah, I'm kind of curious if it would be appropriate to maybe add a general clause under subsection 2, kind of stating engagement with the department on elements of the department's review of the application in general, such as, you know, providing a technical basis for findings in a groundwater review, etc.
Yeah, Austin, if you want to submit specific language that you're looking at, we'd be happy to take a look at that.
Okay, great.
And also just, I guess, thinking about what you said, the point here is not that if the department has looked at best available information and we've made a determination, the point of the admin whole process is not to allow people to just argue with something we're quite certain about based on best available information and professional judgment. Because at that point, we need to move forward and get somebody an answer faster. It shouldn't be used to just hold things indefinitely, or for, years at a time.
Well, the appropriate place in the process, if you disagree with the department's findings, is to protest, right? And so we're spending a lot of time on the back and forth, right? This goes back to the balancing act that we have, right? The more time we spend on one application, the less time we're spending on other applications. So we're trying to find that balance of providing customer service, right, as well as timely processing. And we need to put some, unfortunately, we have to put some bookends on that so that way we can serve more people, right? So that's the challenge here that I'd encourage you all to think about is how can we accomplish that goal of providing timely service to everybody that's in line? And that's the challenge we have. Chris?
Yeah, and I want to thank you for your infinite patience with me. It's always appreciated. On this section, paragraph E, where it says collect annual high water level data, sufficient to evaluate reasonable stable groundwater levels. It seems to me like there is a preference or there's even a permission for a single water user with a well to establish reasonably stable groundwater levels for their interests. But it may be the case that their well may show some reasonably stable groundwater levels for various reasons, but the area around them that is hydraulically connected may actually not be reasonably stable. And so I think it seems, and please correct me if I'm wrong, but it seems wrong for a single well and a water user to say, hey, look, my well seems to be reasonably stable, so I can use it, when in fact the hydraulic connectivity factors within the region actually say otherwise. And so I think that a determination about reasonably stable groundwater levels needs to be more spread out and understood more generally than just in a single well. I think we're seeing that in the Harney Basin right now. So I'd just like to put that out there. Thanks so much.
Chris, thank you for that. I've made a note because I think this is really beyond the scope of this rulemaking, and it's about what's required in the groundwater allocation rules. So I've made a note to myself to follow up on that. I don't know if those rules require what they require, but this is basically requiring or allowing folks to be able to comply with what's in those rules already. So we will take a look at it and see what, I don't know where folks landed on that. That's not a detail I retained, sorry. So we will look into that. I hear what you're saying. I just don't think we are going to change any policy that was already determined on a RAC that spent a lot of time on that particular issue. So I'd like to see what they did and see if there was specificity there and how that approach is put forth in those rules. Greg?
Yeah, thank you. Greg Capillas here. I think just a quick comment on that. I believe that, this provision here is for the situation where an applicant is in an area where the groundwater section doesn't feel like they have sufficient data from other existing wells nearby to make that determination of reasonably stable groundwater levels. So this then provides an option for the applicant to drill their own well and measure their own water levels over the course of 7 years to provide the data that the groundwater section can then use to evaluate that, whether or not groundwater levels are reasonably stable. I just wanted to add that as a point of clarification.
Yes, thank you, Greg. That's correct. Okay, we're going to take a break right now. So return in 5 minutes and we will get started on a new rule division. Thank you all for great feedback, great engagement. I know this is a lot. And we appreciate all of you spending time with us.
Thank
We're here.
I'm very excited by it. Nobody cares.
I paid a higher rate for pirate fees.
Higher rate.
Like the tooth fairy paid a higher rate for the pirate fees, so he felt a little better about it.
Nice. I might actually. I feel great.
It's just tooth fairy getting silver. Fresh smell.
Yeah.
All right.
Exactly.
And on that note,
Oh, that's good. I might have to pick off that.
we are transitioning over to 315. And I'm going to preference 315 extensions with a bit of a commentary. How's that? So I don't intend to go through every single rule division and tell you what they do. But there's a couple key areas I'll point out for you all. And of course, the whole rule division is open for your feedback. But before we go there, I think the hardest part of this rule division, right, Jeffrey, is the applicability section, right, Katie?
Yes.
I think I got volunteered for this one because the applicability section is just so enjoyable. So, I want to give some context around that because that shapes how all of these rules most of the rule changes are really coming from, not all of them, but most of them are coming from the statute. And so with that, I want to talk a little bit about what 3342 did. And Bryn and Jeffrey, I didn't run this by you, so if I say something wrong, it is your job to make sure that I state it correctly. So for 3342, it removes the extensions process for all permits except for municipalities, quasi-municipalities, and group domestic. So it removes the extension process for all permits unless they are a municipality, quasi-municipality, or group domestic. So that means we have a couple buckets here. And Jeffrey and Bryn, I can't see you all, so you're gonna have to move closer so I can see your squirming better. So those are, we have to start parsing through when we talk about this legislation, the different uses, okay? So new permits that are not in one of those three types will get a development time of 7 years instead of 5, but they don't get an extension. And when I say a new permit, that is if the PFO on the water right permit application has not been issued by April 1st. So that is when we get a water right application, we say how long they have to develop. And if we haven't issued a proposed final order, they will get 7 years. If we have, they'll get the current standard, which I think is 5 years. Remember, these are not in those three groups that I listed off, right? This is everything else but those three groups. So for any permits that had a proposed final order prior to April 1st, they can get one extension for 2 years. If good cause is shown and there's fish conditions are met, and if the extension is, if no PFO has been issued on that extension prior to April 1st. So that is kind of the mind, that's just, we're just through that first group. We haven't even gotten to the other group, okay? So, that is, if an extension PFO is issued on April 1, then the current law, or is issued before April 1, the current law applies, okay? And so this bill doesn't apply to it. So, Jeffrey?
I just wanted to make sure there was some clarification based on the early statements you made about no extensions are available. That's only for new permits that have the PFO issued after April 1st.
Yeah.
So regardless of the category. So there are extensions available for permits that are currently out there or with PFO issued prior to April 1st that could come in for an additional extension under the legislation.
Yes,
so-
that's, I don't want to confuse folks. So this is, we're still not talking about muni, quasi-muni, or group domestic, okay? Those ones are separate in this confusing rest, okay? So then we have for this other group here, one, the bill doesn't touch municipalities, so muni extensions, that's not what this bill is about. So we set those aside, we're not gonna talk about munis anymore, okay? But for this bill, it does cap extensions for quasi municipalities and caps it at 20 years. And then for the group domestic expanded, caps it at 10 years. So, and it keeps the criteria the same for those. So it does, let's see. That means that for a quasi municipal permit that is applied for, if it was a new permit, right, then it would be, they get 27 years in total, right? And if it was for quasi-muni, 17 years in total for group domestic. Unless, of course, they're already kind of, that's for new permits, right? For ones that are already have permits, when they come in for their extension, any extension, this bill will apply to any extension applications submitted after April 1. So that's in any new permits submitted after April 1, that's when these new provisions will apply. So if you're a quasi-muni and you've already had 5 extensions and you come in with an extension request before, you'll still be under our current rules. If you come in after April 1, then you'll be under the new extension rules, so you can get one more extension for the 20 years. Up to 20 years. And so that's kind of how that works. So I'll pause there, see if folks have questions about that, because that's basically like a lot of the pieces around the rules kind of get at that issue there. Okay, so Leah.
Hi, thanks. Yeah, I think in several places the word application is used like twice in the same phrase or in the same line, and sometimes it's referring to an extension application, and sometimes it's referring to the water right application for which the permit was issued or the PFO was issued. And I just think it would be helpful in those cases to specify, like, each time. I know it's kind of repetitive, but like, which application are you referring to?
Thank you, that's great feedback.
Like on B, yeah, I think it says like B, extension applications, blah, blah. If the PFO was issued on the application, but there it's talking about the water right application, not about the extension application, so like that.
That's a good comment, thank you, we appreciate that. I think that one was taken from the statute, but I do remember when I was reading that, I was like, what are we talking about again? So we should fix that.
Yeah.
Bryn, did you get that note down? Okay. All right, so I'm not seeing any hands, so I do want to move into the rules. And like I said, I'm not going to describe everything here, but there are a few key pieces that I want to make sure that I highlight. And I think most of the changes are really implementing the bill or a cleanup. In the 2 areas where I think folks probably, at least we should highlight it. so that way you know, right, is on 315.0040. This one is, the key piece I wanna highlight there is that the rule is amended to make clear our longstanding practice of denying applications, and this is for applications for other than muni and quasi-muni. When the permit holder has used, and this is, sorry, applications meaning extension applications, okay, this is the extension section here. When the permit holder has used water and has failed to demonstrate compliance with fish-related permit conditions that are required to be met before water use began. So the department has consistently denied an extension if you did not put in the fish screen before you started using water. You can't cure that. So this is making that clear in the rule, that longstanding practice.
I think that's also in our application form, isn't it, Jeffrey?
It is, noted in the application, yeah.
Do we deny or just deny?
We deny it.
Deny,
Yeah.
okay.
So this is under 315.0040. This is one of the provisions I just want to highlight for folks that I feel like you all might want to look at, just for being transparent. The other item that I think folks will want to look at is 315.0050. And specifically the provision that eliminates the requirement for checkpoint conditions. Because we now have a new limit, and this is again for other than muni and quasi-muni permits. And so this would eliminate that checkpoint condition because we now have limitations on extensions.
And the existing rules say for extensions exceeding 5 years, so if they can only get 2 years anyway, then that's not gonna be, applicable.
So I wanna see what other provisions of the rules either you have questions about, you would like us to describe. I think the cover sheet does a pretty good job of telling you all what's specified by the legislation and what are, updates. But those were the two that I felt like I really should make sure that I was pointing out for the group here. So I will pause there and let you all think a little bit and skim through your notes on these and see if there's pieces that you all would like us to discuss today. Yes, Jeff.
So as long as it's a straight no chaser, converting copy and pasting and putting it in practice. I mean, that's one thing. I mean, I disagree with this bill fundamentally, but as long as the department's just playing it straight and there's ample communication, then there's nothing that this rules committee, and this is one that I was probably pushing my legal counsel about, should we make no comments? And I was told, probably not. So I just like to get that just out there that while I have fundamental disagreements with it, I understand the department's role.
Yeah.
So as long as there's not anything over and above on an interpretation that we might find objectionable, then, what, at this point, there's not much to contribute.
Yeah, I think the two areas that I just highlighted are the ones where I think that's, the other ones I believe are really all just, implementation of the statute. And when I say of the statute, I should say that also includes, I guess I should be clear, because as I was skimming through, I did forget here, there is one provision that is related to munis, which was never updated in the rule. You all may recall that legislation that passed about municipal extensions. 2017, in the definition under 315.0010 sub 6, or sorry, let's see, 7G, which is the undeveloped portion of the permit. That is implementing that statute. That definition had not been updated since that change, so I should flag that. I don't want to mislead folks. There was a definition change here related to that, so. Kimberly?
Yeah, related to that, I mean, you can't, under Oregon law, you can't divert water unless you're putting it to beneficial use. And so here, you have pulled out the words beneficial use. I don't know if that was intentional or not.
I think we were just strictly using the statutory language.
Right, but it's a little tangled in that under Oregon law in general, you can't just divert water absent putting it to beneficial use. So if the word beneficial use is not in here, people might be misled to believe they can just like pull, to show proof of use, they can just pull water through the pipe and not put it to beneficial use. And so that word was actually really important in the original definition, if that makes sense.
We'll take a look at it.
Okay.
Kimberly, I'm reluctant to change the definition because it is verbatim from statute. That doesn't mean that it's, I don't know if it's, we're not very focused on the muni rules, so,
Yeah, and I guess what I'm
I
saying.
don't know if
is
it's
you-
elsewhere in
Yeah,
there.
I guess what I'm saying is you are proposing to change the definition. We would say to stick with the definition. You see what I'm saying? 'Cause the definition right now includes the use beneficial. It says diverted for beneficial use before the extension. Anyway, I'll note it in our written, but just.
Yeah, note it in your written. I would want to go look at the statute because I don't think it is helpful for us to have definitions that conflict with the statute.
Yes, I
And
agree.
we are very good at having many rules and many definitions.
Right, and I guess the point I'm trying to make is under the water code.
No,
in
I know what
whole,
you're saying.
You cannot actually divert water absent putting it to a beneficial use. So regardless of what's in that one section, I would encourage you to look at the code in full, because otherwise the definition doesn't really comply with existing law. That makes sense.
We'll take a look.
It should have been better practice.
Yeah, it's just like about everything.
Commentary.
Yeah.
Okay, I will make note of that. We'll take a look at the beneficial use piece. Oh. Tables.
Thank you. So not saying I agree or disagree with Kimberly's comments, but I do think that definitions matter, and this is one where, several of these definitions are also in the definitions section, which we discussed under Division 305 for those tracking all that. I'm not saying we need to necessarily have the undeveloped portion in the definition section, but I do have concerns about existing statute prior to the bills from this session, conflicting with the other language. So I think it's important that we get it right. But I guess my point in raising my card is just generally speaking, this is one where whether it was intended or not, I think this has some unintended consequences. And as referenced in previous meetings, and this is more for the group as a whole, being able to identify areas that are gonna need to have legislative fixes and holding the legislative sponsors to their word that they would change things that they didn't get quite right. And I do think that just aside from our specific interest, it's not an equitable setup to have folks that are subject to different rules and the department undoubtedly having to process things differently, to say the least, before April versus what they're gonna do after April. And so I just want to flag that there's gonna be some need to address this perhaps in a way that we can't do here in the rulemaking. But I would also suggest or put out there as an idea that it would be helpful at some point for the department to have data, if they don't already, on how many things are in the queue right now that would be subject to the old rules. And which ones they would be under, if that makes sense. Not asking for that now, obviously, but.
Thank you. April, can I ask for one clarification when back to the definitions section? So the only change in the definitions section is the undeveloped portion of the permit, and those rules only apply to municipal extensions. Did you have a comment on the definitions, or were your comments, more about the holistic rulemaking here, or the statute?
The latter part was more of the holistic, but I think specifically you are defining the section as definitions when it wasn't before, and it's more of a, I guess, a structural thing of having sets of definitions that are similar or different than the sets of definitions that are in the division 300. Sorry, I misspoke when I said 305.
Yeah, and we did not want to get into changing the definitions, because these definitions already existed, right, so if folks are wondering where I'm at, I'm on page 2, which is where the definitions are. They already existed, but for some reason the section was just titled purpose. And, so that's why we added as the header definitions, because they were already there, and, we were trying not to make much, knowing that statute didn't make changes on the muni side. The 2025 legislation didn't make changes, but there was 2017 legislation that changed that definition. That's, what was the only change we were proposing, because, the muni side gets very complicated because some statutes have their own definitions in them. So we weren't going there for this one, other than the one that we made change.
I always find it interesting when we're taking things out for streamlining purposes in some places, but not in others, or where there is just certain differences between one definition or another. But I also.
Agree. I would love to dig into that, and we don't have time right now.
And I'm not suggesting we do, but I just, for people tracking, some of it is in there and some of it isn't. And again, I do agree with Kimberly in the need to make sure that we're not making a new definition that conflicts with other definitions.
Okay. Thank you for helping me understand that further. Other comments on the extension rules here? Via.
This is maybe a minor comment, but on 0050 sub 4, which was not, I think, proposed to be changed, but it's saying extensions may be granted for this reasonable time necessary, but now it's limited to 2 years. So it's not just for whatever reasonable time. So does that need to be updated to make more consistent sense with the rest of it?
It's 0050, you said sub 2?
Page 9.
Yeah.
Oh, sorry, sub 4?
Yeah.
We'll
Because
take a
that still
look.
just says the reasonable time necessary, but now it's capped at 2 years for those.
I think that's meant to be reasonable time necessary within those constraints, but we'll take a look and see if any applications warranted.
I had a similar comment on that one, just to clarify that it's one. As opposed to
Oh,
extension.
I see what you're saying.
Yeah.
Yeah.
Okay, I got those. Other comments on this one? Really? No.
Could you explain your rationale again on deleting the checkpoints? I thought you said it was because the flags only to municipal, but I'm not seeing.
The
that.
checkpoints only apply to, they do not apply to quasi-muni and municipal.
So then we're left with group domestic expanded, which could be, it's up to 10 years.
Okay,
So technically if that language was there, it could still apply. But what's the value of it? I think is part of the equation. And then for the other than, which is kind of an internal term we're using for non-muni, quasi-municipal, non-domestic use or domestic use expanded, so everything else. The max they would get is 10 years, and so checkpoints wouldn't apply to them under even the existing language.
okay, and this will not affect existing extensions that have checkpoints or have PFOs.
That's correct.
Okay.
And there's still the requirement, for municipal and quasi-municipal water use permit holders to submit a water management and conservation plan, so we do get additional information through the WMCPs for those folks.
And so what about, I guess one question, a lingering question is, so it doesn't apply to existing extensions, but A is 6A is sort of an ongoing requirement for those water rights that have checkpoints. And so if you knock out this provision of rule, it appears to me that you're knocking out what happens if they don't comply at their checkpoint. So I guess I would just ask that you think about that, because we don't want to get rid of the requirements for the people who already have extensions in play, if that makes sense.
Sorry, what, rule is this again?
I'm sorry, so I'm on
Page 10.
page 10, 0050, what is now 6A, that's crossed out.
And so I think the reason we can verify this, but the reason that this can be struck is because it's the order, right? We issue
So
the
it's in the
extension
order,
order.
it says
The
that.
order actually has the requirement for the checkpoints. The rule is giving us basically the authority for what we put in the order, and then we put in the order, and that's what we hold the permit holder to. So even if our rules change, that doesn't change the terms and conditions of the permit.
Okay, yes.
Correct.
Great, thank you. That was super helpful, thank you.
So now, when they come in though for a new extension, right, we wouldn't require these checkpoints, if that makes sense, right? So they could go from having checkpoints, let's say, and they get one more extension, and then they come in the door for that, next extension, and we say, this is your final extension, you don't get any more, and there's no checkpoints.
Okay.
Does that make sense?
Yes, and just one last clarification, is everything in the order? Please.
Yeah, the conditions are basically verbatim of the
Okay.
rule and stuff.
Okay, great, thank you.
I forgot to mention, we have our extensions guru here today, so.
Jeffrey Pearsall. That's all right.
Okay. Anybody need more time, or should we move on to Division 18? Okay. Division 18, thank you, Jeffrey, for popping in.
Stay.
Jeffrey's got extensions to process.
I got stuff, I got it.
I'll bring
Think about implementation and updating forms.
Okay,
Oh, I gotta tell Lisa, we are.
yes.
Make sure she's back.
It's gotta be more.
I need to grab all the paper you're actually like.
It's gotta be more comfortable.
So we're just gonna get our ACW gurus on the line here, because
That's right.
we're all about efficiency these days, and so we told them that they didn't need to sit through the first two rules here.
They're helping with other rulemaking tasks.
Yeah, we've got a lot on the plate. You all have a lot on the plate, they have a lot on the plate. Okay, so Division 18, allocation of conserved water. So just a brief commentary on this one. Again, not gonna go through every single change, but I do wanna provide some introductory commentary, and then just like we did the last one, open it up, see what you all have thoughts on here. You're gonna start to see a theme across the various rule divisions that we're working on, right? So we did a pretty deep dive today on 310 for new water right permits. And what you'll see on upcoming rules, including this one, is that the legislation, is moving us away from having different terms for the same thing. Thank you. I'm so glad for that. So we used to, in the transfers process or changes to water rights, have something called a preliminary determination, which is very similar to an initial review. Why do we call them different things? No idea. So this shift is moving us towards that. Okay, where everything's gonna now be called, if it was a preliminary determination, it's gonna be called an initial review. The proposed final orders, what do we used to call them before that? Initial or?
Preliminary determination, so transfers had draft preliminary
Oh,
determination.
this is why could I be confused over this?
Right, of course, yeah, it makes sense to make it consistent. So, draft preliminary determinations, or DPDs as we call them colloquially, are in transfers now gonna be called initial reviews. That lines up with new water right applications. And then preliminary determinations are now gonna be called PFOs, the equivalent of that. And
Because
then
nobody else uses preliminary determinations. It's very confusing. So we're very happy about this change. But you'll start to see that within the upcoming rules, because the upcoming rules, including this one, are mostly about changes to water rates and different processes around that. So the other piece to that, though, is that it also has, no, we didn't do two-phased on those. So that's the key piece there to note. So you'll see another theme across the various rule divisions is we're trying to now ensure that one of the criteria for our applications is that if folks have an email address, that they include it, because we'd like to move into the modern age. We've already talked quite a bit about mapping standards and having one consistent standard, and then if we need more information, that's what's included in the rule division. So this does include references to that 305 division for mapping standards that we talked about at the first RAC meeting. And then it also includes the land use issue, right? So compatibility with land use is addressed in this rulemaking. And you might all, given how much discussion there was, you might all want to look at that. So maybe we'll hop to that at some point here, because there's a language that you all saw earlier today related to that. And then if the water is going in stream, there's different language of notice to the local governments. So I'll just note that that issue's arising again. The other thing that's arising again in these changes is the weekly public notice and the contested case provisions, and a lot of this rule change is about implementing the having that proposed final order be able to go to a final order if there's no protest. And so we're moving forward. You get draft certificates at the PFO phase. So then we don't have to issue those at a later date. So that's kind of some of the just initial commentary I wanted to provide, is that you're going to start to see this in some of these similar themes here in other rules. And also to just note here then that, yep, the land use issue's back. The other one, I think you all might want to, so I'll now get into specific rule divisions that I have. We'll start with, let's see, we don't have that many changes, so. Okay.
She's telling us she's here or what.
So we're gonna go to 0040. And, I'm gonna pause before I point towards one item in 0040. Lisa?
Yeah, thanks, Raquel. I just wanted, one thing you noted was the PFO automatic to FO, consistent with House Bill 3544. We've made that only applicable to the approval order. There's 3 orders that happen in an allocation of conserved water.
Lisa, can we pause on that one and come back to that? Okay.
Yep.
So what I've learned from this process is allocation of conserved waters, super complicated. We're not dealing with everything in this rulemaking. I think there's probably a need to come back and talk more about ACW at a future date. And so, Lisa, I think when we get to that rule that starts to implement that, if you can talk more about it at that point. I don't remember which rule division that starts to show up in, or rule section. So let's go to 0040, and the one that I would point out, that one has the information necessary for the department to comply with land use. So that comes up. We don't need to rehash that, but I do want to flag it in case in this context there's different comments on it. And then the other piece that I wanted to make sure you all took a look at. So I'll just note the land use information piece. And like I said, there's the piece that's similar to what we talked about in A. So that's on page 722A. And then the part that's different is 22B. And then the other piece that I wanted to flag for you all is on 25, so page 725, which is reflecting the statute that says the department may. The rule currently says shall. And so this changes it to a may waive application fees based on the percent versus a shall. So I know fees are an important topic for folks, so wanted to make sure we flagged that change there for discussion as well. So opening up it for comments on 0040 based on anything in there, but just notably the ones I think you're probably all interested in. James.
Hey everyone, this is James Razor from Trout Unlimited. Thanks for going to this one. This is the area that I had probably the biggest question from today's materials. On this page 7, subsection 22 about land use information, what is the current practice or requirement for 22A and 22B and the authority for that? I'm just trying to determine which of these, or maybe both of them, are new requirements. You know, what is the change or no change from current requirements? I think it's already required practice for this form to be signed. But I'm just trying to suss out if we're seeing anything different here from what's already done on the ground.
So I am not a land use person or a processor. So phoning a friend here, which one wants to answer that? Lisa or Katie?
I'll go to Lisa.
Okay, Lisa, you've been volunteering.
Yeah, I believe we currently get a signed land use information form on ACW applications already. Corey, you can nod if that's accurate. Okay. Yep. So,
and that would be whether the applicant is keeping and using some water or putting it all in stream.
Yes.
Okay.
So B, is that new then?
Well, I believe this is reflecting what we currently do.
Seeing Corey nod yes.
Yes, current in the current rules, it just says land use information outlined in the department's land use planning procedures guide. And so every application that I've received since I've been in this chair have submitted a land use form, whether they are using their portion on land or putting 100% in stream.
So Corey, is there a requirement that today that the documentation that they submit, if they're proposing to dedicate 100% of the conserved water in stream, that they must provide notice to create an in-stream water rate to the affected local governments for that reach? Is that something that's already a current process, or is that something that's new?
To my knowledge, to me, it appears to be something new. It states on the app, on the very front of the application, the very first page of the ACW application, it says if you are putting 100% water in stream, you do not need to submit land use. But I don't see anything in rule or statute that gives us the authority to say that. So I have had maybe one or two in the past that have submitted an application without land use. And so I was a little confused and had discussions with Lisa, and we just said, yes, please submit a land use form.
So Corey, we'll take, or James, we'll take a closer look at this one for B.
Well, and what I was wanting to follow up on there, that's helpful, Corey and Lisa, thank you. I'm wondering then what the existing authority, statute or otherwise, is for requiring this affected local government approval. You mentioned a land use guide at the department. I'm just wondering where this requirement to get the form signed and approved with a fee likely, where does that come from? Is it in statute? Is it in department guidance?
So the agency as a whole is required to comply with the land use system, right? On actions that we take that are land use program, land use type of actions, right? And so that is where, particularly for at least the first part, if they're going to apply that conserved water on new lands, that's where that comes in. On the question around the in-stream, that is one that I think we need to do a little digging on. I don't know if that came from our land use planning guide. And I don't know if Lisa has more information or not on where that B came from, but I think we need to take a closer look at that one. So I don't have an answer for you at the moment on that part.
Yeah, James, I know we found something to this effect, but I don't want to, we'll make a note of that and get back to you, because I don't want to give you incorrect information. And my brain's been in Division 77 at this point, so I apologize. I don't have the answer right off the bat for you.
That sounds good. Thank you. I mean, for what it's worth, I'll say that if the applicant is putting 100% of the conserved water in stream, it makes reasonable sense to me to not need to go to the local government and pay a fee to get their approval for that. I do like that change. It seems like it can save some time and some nominal expenses, but just trying to figure out where this is coming from. Thank you.
Kimberly and then Jeremy.
Yeah, I had some of the same questions as James, so thanks for bringing that up, and thank you to the department for looking at that. I guess I just wanted to comment on one thing Corey said. So to the extent you guys are looking at this, and what I heard Corey say was, if someone is putting 100% of the water in stream, then they don't have to submit land use information. And so if that's the case, that's very different than what is written here.
It
So,
says, thank you,
yes.
Kimberly, notice of the intent. So it's not getting land use information form filled out by them, but it is notifying the local government. But yeah, we do need to.
Right, which is different though than having a rule that says if you're putting 100% in stream, you don't have to submit land use information. So in other words, you wouldn't have to go to the county, you wouldn't have to notice, you wouldn't have to do anything if it's 100% is in stream. So just wanted to point out that. Okay.
Jeremy?
Yeah, Jeremy with Central Oregon Land Watch. Appreciate the discussion on this one. I don't have much more to add today, but did just want to note that that I'm going to consult with some of our land use experts on staff to provide feedback both here and on Division 310 per the conversation earlier. So appreciate the attention to this issue.
Thank you, Jeremy. We appreciate more feedback on land use from folks that have expertise there. April?
Okay, I think I have three things. I'll do my best to
Okay.
remember all three. One, I think in the context of this set of rules, page 722, sub A, partially for the benefit of Lisa and Corey that are jumping over, we had some conversations about this particular language in the context of Division 310 and the water right application processing and the change from existing language in that set where it's information form and changing it to be where it's got this language that has it being compatible. I didn't explain that very well, but I guess part of my point is this in relation to the conversation we had earlier with folks getting together with some language. I think it would be important to revisit this section when we revisit that definition, because there should be similar language in both. If we can agree upon that language, if not, it needs to revert to what was originally there specifically in 310. And then in relation to 22B, also on page 7 of the Division 18 rules, I think my questions are coming from maybe a different direction, but I think similarly understanding where this language comes from, the statutory background or other rules it's pulling in. I do think it's my brain, there's something back there that's telling me, you know, there are requirements about notice when there's an in-stream water right that's being filed regardless of who's filing it, but that would be good to also, I think, revisit. And as Katie, you've done indicating where it's coming from. Is it from the bill? Is it pulling something from another reference? That would be helpful. And then I think just broadly, it is interesting as someone who represents irrigation districts that serve water to farmers and ranchers. We use a variety of these transactions, and we do have both patrons and districts that have used the allocation of conserved water. So I'm just making sure folks know that just because we are perceived as a consumptive water user, we do have an interest in seeing these tools be available as well. I think generally, and I will go through the section and get some more comments written wise, but just the level of red that's in here, and I'm saying my comments now because as you guys know, I'm gonna have to leave early. It does give me some concern that we may be making this process more difficult. And it is something that, as you acknowledged, Raquel, there's a number of us who maybe coming from different perspectives, but have a shared interest in seeing this program work well. We may not be able to do that through this rulemaking, but I certainly don't want to see us make it more complicated.
Yeah,
Unnecessarily.
April, I'll respond to that one, because when I saw this, I also was like, why so much red? Because, so just contextually, for folks, in terms of this rulemaking, we had set out from the start, there's gonna be some of the rule divisions where we do a deeper dive into them, and those were set out to be basically in-stream leases, transfers, and just in-stream leases, in-stream transfers, and transfers. So Division 380 and 77 essentially. And that was from, you know, knowing that we have limited time, but that also there'd already been a lot of work to identify efficiencies in changes to those areas of rules. We even had a prior RAC on Division 77 that for various reasons, transfers of stored water, our favorite topic, stalled out, and so bringing back those changes. And so those were the two that we knew was gonna have a deeper dive, along with Division 2, the contested case one. This one was one I was not anticipating a deep dive on, and that's where, in looking at it, I realized that a lot of it was really around this piece about the steps in the process. So we can always come back to what's it called? What division was I just in? To 40? But yeah, to 40. But I want to move into 50 just because since April is still here. And Lisa, go into that spiel you were about to go into before I asked you to hold. Because most of the changes is a result of how we run ACW, and there's like 3 different steps in the process, which I learned about. So Lisa, can you give that overview for folks? And that will give some context around some of the changes here. I'll also note that some of the red is because we moved down some of the content, and so it's not new language really, it's moved down. So there's also some of that going on in this whole division. And Katie has something, and then we'll go to Lisa.
So just, so thank you, Lisa, sorry. A lot of the changes in here too are because of the House Bill 3342 would have a PFO become a final order by default, 33 days past the protest period ending. If nobody protests and we don't take another action in that time frame. So Lisa's gonna walk through the different steps in the ACW process, but that does mean that we need to make sure that we've got the inclusion of conditions, if applicable, cancellation of the original water rights certificate and preparation of draft certificates within the PFO, so that if it becomes final order by default, it's got everything that's needed in there. So turning it over to you, Lisa.
Yeah, thank you. Yeah, so just real high level, there are 3 stages to an allocation of conserved water. There's the approval of the conservation project. So once the applicant gets that approval, they can move forward with constructing the conservation project. Then there's completion, the completion stage. So once construction is complete, the applicant files a notice of completion, at which point we would issue a completion order. And then the applicant has 5 years to test the conservation project to ensure it's performing as they anticipate it will. Then following that, after the testing phase, the applicant submits a request for finalization. We issue the finalization order where we allocate the applicant's portion of conserved water and the state's, excuse me, the state's portion of conserved water. And at this point, we're done. We issue an in-stream water right for the state's portion of conserved water. The applicant can use their portion of conserved water on new lands, or they can reserve it in stream for future out of stream use. And then we issue a reduced remaining right for the from lands that were involved in the ACW. That water right gets canceled, that original water right gets canceled when we issue the completion order, I think it is. But the twist to this is that we can issue an approval order on its own, and then a completion order, and then a finalization order. If when the application is filed, they can file the ACW within 5 years of completing the conservation project. So it could already be done. And in that case, we would issue an approval and a completion order in the same order. And then at that point, they get to go about testing and making sure it works. Or they could be entirely done with the project as long as it was done within the 5 years prior of application submittal. So we could have kind of the 3-in-1, an approval, a completion, and a finalization order all in one. And so we constructed this part of the rules 0050 to contemplate all of that, because the proposed final order, if not protested, will become final. So we need to make sure that, like Katie said, the cancellation of the original right is in there at the right time. Let's see, if they've done approval and completion, but not finalization, we don't want to put the in-stream water right in that initial order, because then it would become final. So we have to kind of think about, okay, what stage are they at? What is okay to become final if the PFO does not get protested? So that's a lot of the nuances in this section. Corey, Corey, if I missed anything, feel free.
No, you explained it very well. Yeah, I can issue anywhere from 1 order to 2 orders or 3 final orders. So I'm trying to lay it out in a way that works with this program. Not easy to do.
So I'm gonna point towards just a couple things here. So House Bill 3544, Section 15. So that applies the proposed final order language and ties it to the contested case Division 2, as well as that 33 days. So some of this is being driven by, we want to make sure that proposed final order, if it's going to become final, so we don't have to issue another document, right? Which is where we found there's some efficiencies to be had. We want to make sure that proposed final order is correct, right? And so that is, the statute doesn't require an initial review, but that is why we're including that, is in part because it gives us the ability to make sure that that proposed final order is going to be in good shape. So I want to go to brief. There's a couple more items I want to just point out to folks. And all of this, we'll open it up to all the rules. I want to point out specifically that 0050 does include language. We've received a lot of questions about this over the years, so I just want to make sure I point it out, is that it does provide a process for allocating conserved water to the state when the conserved water is a result of a water conservation project involving groundwater rights. So OWRD has been allowing groundwater rights to go through the allocation of conserved water program. And so this puts that in there and puts it in the rule. So I want to make sure folks are aware of that. So that's under 0050. It also appears, just because of the structure of the rules, in 0065, that groundwater piece. The other, I guess that was the key piece that I wanted to make sure that I pointed out. So, land use compatibility does show up with the same language, throughout these rules as well, but we've already touched on that. So I think those are the key pieces I wanted to make sure I pointed out to folks. So Kimberly, and then Chris.
Yeah, we just want to flag to folks that we have some pretty significant concerns with this, only because currently the state doesn't have the ability to protect that water in the ground from other users. So it's not necessarily a public benefit. I think the idea behind the Conserved Water Act was that there would, you would have a public benefit in stream flows. And it's not that we're opposed to expanding this to groundwater, but we are opposed to expanding it to groundwater if there's not a way to protect that water in the ground. Because right now, the way we're understanding this language is it would just basically allow water spreading and increasing consumptive use. So, happy to talk to users across the spectrum about how this could become successful in the future. I think there's a lot of interest in it, but again, from our perspective, we need to be able to protect the water. Yeah.
Okay. So we might want to talk a little bit more about that, and because right now we're just canceling. Is that what it is?
I will ask them.
Lisa, right now we're canceling the groundwater, right? The portion that is the state's portion. Is that transferred to the state, for example?
We just, we issue the reduced remaining right on the original water right. So we cancel the original water right, issue the reduced remaining right, and then the state's portion of conserved water is just left in the aquifer for the next user. So we're not protecting the groundwater. It's just available.
Got it. Thank you. Okay. Chris, and then James.
Yes, at the risk of repeating what Kimberly said, but I have some prepared remarks here. If OWRD extends the program to groundwater without creating a legal mechanism to hold the conserved portion in ground with a water right, then the conserved volume would immediately appear as newly available water for appropriation. And that would completely neutralize, if not misrepresent, the conservation benefit. And I don't even think such a concept belongs in this section of the rules, if that's the case. To me, this looks like it might be a water market provision by some other name or by other means. It feels like a water market. And if not, maybe just like an inadvertent water market. And for actual conservation to logically work, which one assumes that's the intent ultimately, there would need to be an in-ground designation that is similar to in-stream designations, which I think that the legislature could easily fix or patch up, barring political obstruction against having in-ground water rights. Thanks so much. Appreciate it.
Thank you, Chris.
This is James with TU again. A couple other folks got in line ahead of me on this one. So I just wanted to share the doubt about this language regarding sort of groundwater equivalents of in-stream water rights. I frankly did not realize Oregon did this already for groundwater. I'd be interested in learning more about when that started and how much it's been done. The idea of using public funding to make groundwater more efficient and then taking the state's portion and appropriating it anyway doesn't make a whole lot of sense to me as far as conservation and environmental benefit and wise use of public funds. I would just like to learn more if it would be possible to get a sense of when and where this has occurred and to what extent. I thought we didn't do this because we don't have a groundwater equivalent of in-stream water rights. I think I do see the language in ORS 537.470 that WRD would be relying upon. But Lisa, the information you provided was interesting and helpful, and I'd like to know more. Thank you.
Okay, thanks. I've made note of that, James. Jeremy.
Yeah, I don't have much more to add, just echoing what's been said. I similarly did not realize that this process was available for groundwater. And I think as Lisa described, the process that's been occurring raises some pretty significant concerns just around the language that's proposed here. So nothing further to add, but echoing the concerns others have flagged.
Okay, here's a question, and we'll go back and look at the statute, but if there is a way to make the conserved portion of the state's water a state groundwater right? I'm just being philosophical here, folks. I'm not saying we can do this, okay? Would that address the concerns that I'm hearing from some of the folks if the state was able to retain that portion is a groundwater rate? Chris?
Yeah, about this time last year, actually, it was in the spring of 2024, Water League submitted an extensive legislative proposal or concept specifically along these lines, and we would be more than delighted to resubmit that again. Thanks so much.
So Chris, is that a yes? You'd be supportive if the state had a state-held groundwater rate?
Yes, absolutely. So if there was an equivalent in-ground water right that could protect the conserved water that has perhaps a seniority to it that is legitimate and capable of doing its job, yeah, that would be fabulous.
JR.
I think we're going off the rails here. I didn't sign up, nor do I have my hydrogeologists or legal experts here to talk about how we want to move forward with our groundwater banking program in our basin. I understand we need to talk about allocation of conserved water for groundwater, but I thought we were implementing process improvement legislation, and what we're getting into is again, a substantive discussion about a new program, which has different applications or implications to other areas of the state. And I think if we're gonna talk about that, we need to table it and probably have it be its own discussion.
Okay, so the reason this was in here, so JR, we're not trying to do any funny.
But we're going off the rails on what people are recommending.
Yeah, okay, I agree.
Because I do not agree that there should be just a de facto give it to the state without a plan around what the best use of that water is. In-stream leases are different. That water's on, it's that year's lease. Whereas stored water and groundwater in different reservoirs with different, uses and different implications of protection of that use for certain one use or the other, which is completely basin specific and requires a little bit more of an in-depth.
So, okay, so I'm just noting that this was included because it's a practice the agency is doing, so we will take a look at it. I'm hearing the concerns around the room, so we'll take a closer look. Other comments here? James?
Mr. Kell, I just wanted to follow up on what you said there because I think putting into administrative rule what things only because WRD currently does them raises concern for me. I see the purpose of these rules and the cleanups as implementing statute and other legal authority. I am less confident about writing things into the rule just because they're what the agency happens to do already, which is what this sounds a little bit like.
So James, I understand your concern and I want to make sure I'm being clear about it. There are some things that the agency does that, to be transparent, we should be putting in a rule, right? So I don't want folks to take away from this that there is nothing that we shouldn't be putting that into a rule, right? Because that's a transparency piece there. I hear the concerns around this particular one and that, so we need to have some more conversations as to whether this one should go in the rule. So just want to be clear that there will still be some things in this rulemaking, right, that we will be putting in there to make clear what the agency practice is that we think we have authority to do. I hear this one is maybe going beyond the question of what agency practice versus getting into some bigger policy implications, which I think is a question, right, as to whether it should be in this rulemaking for this time. So I
Yep,
appreciate.
that's exactly right. Thank you.
All right. Thank you all. This is helpful commentary here. Anything else on ACW that you all would like to discuss today? Leah, I apologize, I left you hanging. I'll note that your background is kind of yellow and your hand is kind of yellow up there. And so I keep missing you. So thank you, Laura, for seeing that your hand was up, because back here, it kind of all looks the same to me. So thank you. Go ahead.
Oh, no worries. I actually just put my hand up, so you're good. I blurred it in case that helps. I don't know if it does or not. I had two things on the ACW.
Okay.
One first, actually, I really want to say thank you for making it a lot clearer between completion and finalization. I think that's really super helpful. There's just one spot where I think it's still not clear which one is mentioned or intended, and that's in 0012 sub 3, kind of towards the top. Because the last sentence of that talks about final completion, and I think based on the context that it should just be finalization, but I'm not totally sure.
Where are you, Leah? I'm sorry, I'm lost.
0012 sub 3.
What page number are you on?
Two.
See.
Okay. Okay, and then you said, I think it's up one more.
It's at the top of page 4, I think.
Oh,
002, and then. What was this under 002?
0012, and then it's 3. Oh, up before that.
0012, way up here. Somebody said page.
So pop at top of page 2.
1 or 2.
It's labeled page 2, but it's like PDF page 4. Yeah, so that, but then the next page, the sub 3. The last sentence talks about after final completion of the project and issuance of the new certificates, and I think that should just be finalization, if that's correct, or completion, but not final completion, because that's like, now we have another thing.
I think you're right, Leah. I think it's talking about after the testing phase, when they notify us that they're ready to finalize.
Okay.
So I didn't catch that. It should be, so we would strike the last that part and replace it with just completion of the project, or?
I think it's finalization.
Finalization.
Yeah, until after finalization, a finalization order is issued. Something along those lines.
Great, got it.
And
Leah,
then
did you see that 2 things? You had another thing, right?
yes, the second one was on 0050 sub 5. Let me see what page is that. I'm just looking at my notes, not the actual thing.
Okay, 00 sub 5 is on page 9.
Okay, yeah, sub 5. Yeah, so under like little a, big B, oh, I guess that's on the next page. And then also little b, big B, and C, it all talks about the original water rights certificate held by the applicant. And I think what previously it just said the original water rights certificate. So I'm wondering if we have to have it say held by the applicant, like if that's in statute, then I understand. But my understanding is that currently the applicant does not have to be the one that holds the certificate. So this would be adding that as a new requirement. Because in some cases, you know, somebody might be leasing the property and they want to do a conservation project with the consent of the landowner, that's the water right holder, and they would fill out, you know, the that affidavit of consent to transfer essentially form and submit that. But this is making it sound like now they can't do that anymore. But if we just took out held by the applicant, which I don't think was in the original language, in a couple of spots, that would make it conform to the current practice. That as long as you have the consent of the landowner, you know, you're not making random changes, but yeah.
So we will take a look at that. Yeah, that's a good flag. I'm not seeing anybody jumping to respond, so we'll take a look at it more closely and get back on that comment. Thank you for catching that.
Yeah, thanks, Leah.
So, Lisa, go ahead.
I was just saying thanks, Leah. I think that's a good point for us just to clarify. Yeah.
Getting good stuff today. Thank you all. Kimberly.
I just have a question.
Yeah.
For those who are more involved in these projects than we are, is there the only opportunity to comment on the application? Or is there an opportunity to comment on the IR? I didn't see that. I may just have missed it.
Lisa, when is the comment opportunity for these applications? You know, is it on the IR or is it on? Well, it'd be on
What
the,
would now be the IR? Right?
is it on the, what would now, it would be the now IR, and then the PFO would be a protest period, right?
Okay, I must have missed it.
Yeah, I believe so. Trying to put
There's a section
my
that
finger
says
on it.
comment on the application, then it says the IR goes to the applicant for review. Anyway, just flagging it, just, I may
Yeah,
have missed it in my.
I wish I had that version up so I could do Control F. But I don't have, I was using a paper copy, so let me get to see if there's a.
So Raquel,
Yeah.
in 0050, section 2, so when we receive the application, then we do a public notice for 20 days to accept comments on the application. And we consider those comments as part of our initial review. That's kind of in section 2, 3, and 4 of 0050.
And I guess the question is if there's not a comment period on the IR, again, I would defer to the people who do these, like, you know, DRC and folks, but it seems like if we're trying to be consistent across all these processes, we would have a comment period after the IR as opposed to the application, because we don't know what you guys are proposing. That's just a question. I would defer to folks who actually do these projects, but
Yeah, I'm not.
I just
seeing-
couldn't find it anywhere, so just noting.
If I may, Raquel, that's in 537.470, the ACW statutes, that upon receipt of the application, we give notice. So that's what we've always done. It's kind of backwards from the other processes.
Yeah, so because it's in statute, it says once we receive it, we will notice it. We're not intending to add additional steps, so I don't think we're inclined to include an additional comment period.
Yeah.
So, yeah, then the comment period is upfront, unlike other processes.
Yeah, and I guess my question is if I know you have to notice it, but I guess my question is for the people who do these, does it make more sense to have, if you're just gonna have one comment period after the IR versus the application? We can stop, we can.
That's
I'll ask some of the
I'm
folks
taking
who
that
do
as
this.
a question into the ether of these folks. And Lisa, what, you said that was under
It's under 537.470, section 1.
I'm not
Yeah.
trying to take a lot of time with it.
Yeah, so 537.470 says upon receipt of an application, jury shall give notice in accordance with 540, 525. So I think that that one could be one, just noting that we're trying to be efficient. But if folks think that that is something that should be put on the list for conversation with the legislature about moving that back, happy to have that conversation. Obviously, that would not be addressed in this rulemaking, but. Okay,
I would just comment really quick on these, that most of that initial conversation when we're a part of these it's all math. It's horsepower, it's, volumetric measurement devices, the difference in sprinkler packages. And so, I mean, it's already a certificate in large but beneficial use, and you're really getting to the math of, what you're saving. And so I think the system works, and I mean, we haven't had any problem with it because there's a lot of back and forth on, justification of the math more than anything. So how much were you pumping and how much are you saving?
thank you for that. All right,
It's way beyond me. It's the engineers that.
we are going to go ahead and move to wrap up and public comment. Laura, what's the wrap up for us? And then we'll go to comment, if there's any public comment. 1 second. Slide. So you all get to see our shining faces tomorrow. Aren't you excited?
Delighted.
Oh, there's the enthusiasm I'm looking for.
Yay. Okay, all right. Yep, so, we finished, we did finish 18 sufficiently, so that's, I think we had a placeholder that we might carry that over tomorrow, so it sounds like we're spending tomorrow on Division 17. If we get through Division 17, we may start on Division 380. Otherwise 380 will be started and hopefully.
My goal is that we start it tomorrow, because if you looked
It's
at
a
the stack
long-
of papers, that's the one that is very,
60
very,
something pages.
very long.
Yeah, so, and we were asking for feedback on what we talked about today, by the 31st. And so that would give you, a couple of weeks to do that.
So folks, we've pushed a lot of rules to you. We've tried to get them to you as early as possible. Some of them we've had for a while, and some of them you've received more recently. The sooner you can get us feedback, you do not have to wait. You don't even have to wait until we have the first RAC discussion. You can always submit your comments as early as possible in the process. But I also recognize all of us are trying to get through these rules, so there's quite a bit there, but this would be written feedback if there's anything else we should consider.
And it's not on here because it's gonna be on tomorrow's, but I believe we have 17. We're asking for that feedback by the 31st as well, since it's.
We're getting in crunch time.
Yeah, we're getting crunch time, so, we got confirmation that October 31st would work for the Division 2 follow-up. So if there are other RAC members that want to join that, please send me an email so we can send you the information. We'll record it, right? And provide the, revised Division 2 rules to the entire RAC, but that, we'll have another version that reflects coordination going on between WRD and OAH. So there'll be some updates to go over, as well as some processing of some of the input we've already received, and then talking about some of the other issues. And then I think that is all I have, so, do you want to say anything more, or?
No, let's see, do we have
Public
anybody
comment.
from the public that has comments today?
Mindy put something in the chat.
Please raise your hand. Okay, I'm not seeing any hands raised. Thank you all for your time and the great feedback and really digging into these rules. It's, yes, you can leave those here. Stop recording. You can also do it.
Yeah, if y'all wanna leave your visitor badges here, we can take care of that for you.